AI
R. Hawker.
R. Hawk Learned Counsel for the petitioner seeks to withdraw this bail petition upon instructions. It is submitted that in the meantime, charge sheet has also been laid upon completion of investigation. So the prayer is allowed. Bail petition disposed of upon withdrawal.
Obliged, Lord.
May please, Lord. Act number 1, my lord. You can instruct it to file additional affidavit, my lord. So
Yes,
some time may be required for you.
not today.
The petition of the interim, my lord.
We have received
The Mr. N. Mahajan, Learned Counsel for the petition, seeks some time to file an additional affidavit. Prayer is allowed. This is case diary has been.
Yes, it is the case they received.
It is
We
received.
received a case there, yes.
You retain the case diary then. Retain the case.
We can take it.
Case diary may be
Take
retained.
up.
Interim bail stands extended till the next date of listing. You, what date would you prefer?
20th, my lord.
20.
20. Obliged, my lord.
May please, your lordship. Anticipatory bail application, my lord, FIR is at page number 15, my lord. This is a cross FIR, my lord. 15, my lord. There are, my lord, 11 accused, my lord. And out of 11, my lord, 6 accused has already got bail in the learned session court Dorong on 2nd of this month, my lord.
Allegations are
But
quite
it's
serious.
It's a cross case, my lord. What happened, my lord? There is a land dispute on that land dispute, my lord. When my family members were employing the land, my lord, then suddenly the family member of the informant attacked us. And on this issue, my lord, we have lost an FIR. On the next day, this FIR was lost against us, my lord. And on 2nd of January, my lord, on learned session, thus Dorong has already granted anticipatory bail to 6 of the accused, my lord. So it's basically a cross case to harass us because we have for the attack which was inflicted upon us, my lord, we have already logged in FIR. My lord. That FIR is at page number, my lord. On the very same day when we are attacked, my lord, on that day, my lord, FIR was lost against.
Page 25.
That is, my lord, at page 25, my lord. This is the FIR lost by my Lal Batra. He was also made an accused in the.
From your side, this.
Yes,
FIR
my lord. And when we lost this FIR, my lord, immediately on the next date, my lord, this FIR was lost against us. And at this stage, my lord, TD may be called for of the both cases, my lord, and interim protection may be given, my lord, because other accused are already granted anticipatory bail, my lord.
All these 4 accused granted anticipatory bail.
All, my lord, may I name them, my lord? They are Matlab Ali, Ali Hussein, accused number 1, 2, 3, 5, 10 and 11 of the FIR for which I have approached before this honorable court, my lord.
Okay.
They are granted bail. On the other case also, my lord, those accused are also granted bail, my lord. So far, I got the instruction, my lord. So interim protection may be given, my lord, and CD may be called for both the cases, my lord.
Otherwise, the injury was there.
Serious allegation.
Yes.
This is the order, my lord, but with the injury report, my lord, CD may be called for interim protection. May
Call
be.
for third so-and-so. Full stop. The 4 petitioners herein are seeking anticipatory bail on the 482 BNSS in connection with Shampur PS case number. Then which district? Shampur?
Shampur is the wrong, my lord.
Shampur PS case number 23 of 2025. The allegations in the FIR are about the causing of assault in a serious manner and leading to grave injuries. 11 accused persons are named in the FIR. The FIR is dated 15/10/2025. The learned Petitioner Council has drawn my attention to another FIR dated 14/10/2025 lodged by, who lodged this FIR?
That was lost by the accused number 5, Lal Batra of the FIR lodged on 15 against Fast my lord.
नाही यार तुमच्या side
He is the brother of the present petitioner, brother, his relative, brother of two petitioners and brother-in-law of another petitioner.
By one Lal Bacha, who is stated to be the brother of
Petitioner number
one.
1, 2, and my lord, 4,
Brother of petitioner number 1, 2, and 4.
my lord.
It is submitted that the said affair is dated 14/10/2025. That is one day earlier to the FIR, which in connection with which bail is being paid. It is also submitted that some of the FIR named accused persons have been granted pre-arrest bail by the learned session judge Durham. All for the case diary along with the injury, however, in the interim, the event of arrest of the petitioner in connection with this case, 25,000 each. Conditions for the cooperative remaining investigation. Appear before IO for examination. Number 3, not hamper temporary evidence, not commit any illegal
Highly obliged.
offenses. It is standard conditions, so that will be more, so we'll save time.
Highly obliged.
Well, I'm sorry for the interruption, Malad. I missed the mention, Malad. Malad, one,
Just a minute. Just- The date you take the date.
27 one lordship.
27 1. You want to make a mention?
yes, Malad, one anticipated bail application was filed on 5th of Malad January, Malad, tomorrow, Malad. March, Malad.
I'm sorry, Lord.
I can take
it after some time.
Obliged.
Peter, at 2, my lord, we are appearing in item number 3, we could not follow, my lord, what order.
Timeless, time pass करू.
2 o'clock. So let it be at
I
2, my lord.
cannot say, actually, we have not fixed two after some time.
No, he is actually is asking for 2, my lord.
We are not
Okay.
After, whenever both of you are ready, we'll take.
Mine.
No problem. 4. Next. 4. Sixty-one.
This is the second time application, Lordship. Earlier, Lordship has rejected the FIR at page 16, Lordship. I'm only on the detention period, Lordship. The 60, mandatory period is 60 days, and today is the 54 days, Lordship. FIR at page 16.
Page.
16.
I can read from here. also.
1/6.
For the huge amount of money, right?
Lordship?
Now this, some misappropriation allegations.
Yes,
right?
Lordship. Only 54 days, Lordship, and he was interrogated for 5 days police custody. Nothing has been recovered till date, Lordship.
Statutory period, when it will be over, which day?
60 days, Lordship.
No, which day it will be?
Today is the
64
54 days, Lordship.
54 days.
So it will be within the
Another 6
package.
days.
So
At
considering
the
that,
time, you can take it, otherwise, not inclined to allow it interim actually. Because of
considering
nature
the
of
detention,
allegations.
Lordship.
Anyway, so you can, let us call for the updated case there.
No, Lordship, then Lordship, I have to withdraw because after it will be vacation
I
start.
am not inclined to give interim because of the nature of the allegations. Huh?
Allegation is there, but nothing has been recovered, Lordship.
Because earlier it was rejected also.
Yes,
and
sir,
allegations
rejection
are
order
also
is
there,
that-
More than 1 crore of misappropriation, so at least.
Amount is huge.
So that's why I'm not inclined. So, but if the statutory period is over, do one thing, we can call for the case diary and then in the meantime, you can seek bail or you want to withdraw.
Yes, sir, withdraw because in the vacation will start in the 19th.
Otherwise, you fix it tomorrow. But tomorrow unlikely.
Tomorrow,
Tomorrow, Lordship, let's
Leave
try.
from-
it is from Tinsukia.
Unlikely, very unlikely. It will be not practical.
Considering the detention, Lordship, only 54 days, Lordship, 6 days is remains, Lordship. And section 3165 is not come because he is not a public servant, Lordship. He is the supervisor of the warehouse. Allegation is that the articles are missing from the warehouse.
This is a subsequent bill application. As an earlier bail petition was rejected on 8/12/2025 in BA 3871 of 25. After perusal of case diary. So, learned counsel fairly submits that he's only on the length of detention, which is 54 days as on today. Vis-a-vis the applicable statutory period of 60 days. So, the next few days being holidays, it appears that the statutory period would be over in the midst of the same. So, however, call for the updated case diary from the concerned police station. Considering the aforesaid aspect as stated above, it is directed that in the interim, the accused is allowed to go on bail of rupees 30,000 with one surety of the like amount to the satisfaction of the concerned learned court and subject to the condition that he shall cooperate with remaining investigation and shall not hamper or temper the shall not misuse his liberty to comply with the standard. So fix it on 27. 27. Publish.
Lordship, there is another matter, Lordship 60. We have not mentioned it, but someone else.
Yeah, that's what I thought, because I don't remember this being
Lordship,
mentioned.
60,
It has been mentioned. I,
that should not have been mentioned, Your Lordship. I am the counsel for the
Oh,
petition.
number 62. अपना 60.
I have not signed any order, so you can, we'll take it up. No problem.
60, 62, 63, Your Lordship. This is from Dispur, Your Lordship. Probably fix the one case, Your Lordship, on tomorrow, Your Lordship, on 9th, Your Lordship. For case diary.
Is it connected?
60, 62, 63, Your Lordship.
60, 62, 63.
These are all
I see.
related to Dispur PS, Your Lordship. Your
Subsequent petition.
Subsequent petition. Your Lordship has fixed. Now, Your Lordship, 72 days, Your Lordship.
Okay.
You have that 73 days to
We'll
do.
call tomorrow.
Tomorrow.
Not cheap. 60, 62, 63. Heard as Bordhapuran. Call for the case diary of dispute PS case number 875 of 2025. Full stop. List on 9/1/2026. Along with
Along with the
connected bail application.
Lordship. I will give it the number.
Come.
Deeply obliged.
Now, as connected bail applications are stated to be listed tomorrow.
Wait, the anticipatory bail application. Basically, two FIRs were lodged, my lord. There was an incident of altercation
Mhm.
which took place between two families, my lord.
Mhm.
Your lordship will kindly come to page 11, my lord. This is the FIR against us, my lord. The relevant portion, your lordship will find it page 12. May I read the FIR? Sir, with all due respect, the informant begs to state that on 13/11/2025 at around 9 p.m. Your lordship will kindly mark the time at 9 p.m. at night. The above mentioned accused persons entered the house of my nephew and inflicted serious injuries upon my nephew Siddiqur Rahman by striking Siddiqur on his head with an iron rod and inflicted injuries upon his mother Hazira Khatun, his wife Masada Khatun by assaulting her. As a result, Siddiqur Rahman has to be taken to Nagaon PHC for treatment. Thereafter, he was referred to Nagaon Medical College and Hospital, and subsequently he was taken to Guwahati Medical College and Hospital. The accused, after beating the informant's family members, broke open a box, took away gold ornaments and cash amount of 10,000 rupees. While leaving, the accused also threatened that if any legal action is taken against them, they would kill Siddiqui as well as the informant. It is also to be noted that the accused persons are also involved in the sale of drug alcohol. So all the allegations under the sun have been made. Now, your lordship will kindly come to page 20, madam. This is the FIR lodged by the petitioner. Madam. Sir, with all due respect, I beg to state that when he went to the shop of the accused persons number 3 and 4 at around 4 p.m. So here the timing is, your lordship,
Just a minute, I
Right.
lost track, just a minute. It is page,
page 20, my lord.
page. This was lodged on the same day.
Same day, my lord. With all due respect, I beg to state that when he went to the shop of the accused persons number 3 and 4 at around 4 p.m. in order to settle an old debt, and when he asked for the owed money, the accused persons number 2, 3, and 4 caused him grievous injuries by inflicting punches and kicks, and upon knowing that we took my son, Azharul Islam, for medical treatment with the assistance of personnel from Dogao PP. And when we reached home, the accused number 1, who had come from Nogao, united all the family members and trespassed into our house, and by using iron rods, bamboo sticks, caused grievous injuries by beating Muhammad Azharul Islam and Asma Begum. While being taken to Dogao PHC, as the injuries were serious, the injured victims were then forwarded to Nogao. Currently, he is in Nogao Due Care Hospital. I was also beaten up. The medical documents are enclosed here. So this FIR also is also registered under sections 3294 and 1182 and 35 of the PNS, causing grievous injuries by a sharp weapon. And the FIR against us, my lord, that has also been lodged,
Both are dated same,
same dated, my lord.
15/11.
And our FIR is pertains to an incident which took place at 4 p.m., whereas their allegation is that the incident which they allege, it took place at 9 p.m. my lord. Both claim that they have sustained grievous injuries on being attacked with iron rods, my lord. A fight definitely took place, my lord. That is becomes apparent, my lord. The only thing at this stage, my lord, if I may pray before your lordship, petitioners number 5 and 6, they are women, my lord, and they have also been implicated in this case. So for 5 and 6, if your lordship is inclined to consider the interim prayer, my lord. Others, your lordship may consider after case diary.
Third S. Nawaz, Land Council, repeat your son. Invoking 480, petitioners here seeking anticipatory bail in connection with Julia PS case number 277 of 25, parental section. And the allegation in the FIR dated 15/11/2025, 14/11/2025 is about the accused persons trespassing into the house of the informant and causing assault leading to injuries, and also snatching away some money and valuables. The learned, Mr. Nawaz, learned counsel submits that this FIR was lodged after one Sultan Abbas, who's one of the petitioners.
One of the petitioners, my lord.
Sultan Abbas, petitioner number 1, had lodged an FIR.
No, my lord, the FIR, our FIR is subsequent, my lord. Their FIR is first.
FIR against 6 accused persons with similar allegations of assault, etc. At this stage, the learned counsel submits that he prays for some interim protection for petitioner number 5 and 6, who are women. Call for the case diary along with medical report. Accepting the said prayer is directed that in the interim, in the event of arrest of petitioner number 5 and 6, namely so and so, 25,000 each, subject to the usual condition. This is the matter on 27 or earlier you want?
22, 22.
22.
DP of it.
Is also yours.
Your lordship, may the matter be passed over for the time being.
After some.
Much obligation.
This is anticipatory bail application, Lordship. Allegation is 3032, and the vehicle has already been recovered, Lordship, and from the others, position of the other accused, not from my position, Lordship. And Lordship will find the affair in page number 12, Lordship. No notice has been issued to me to appear before the IO till today. Police is after me, Lordship. It's in page number 12 is the affair, Lordship.
Yes,
May
let
I
us
read,
see that.
Lordship?
no? What is the allegation? At night,
It is respectfully submitted that on last 30/10/2025 at night time, a Mahindra pickup Bolero bearing so and so registered in my name was parked in front of the shop of Abdul Hanif Sheikh. On 31/10/25 morning at about 4:30 AM, I went there and found that my vehicle is missing. Some unknown person might have stolen away my vehicle. Now, Lordship, kindly turn to the page 12, Lordship. That is the inquiry report of the police. Your Lordship, in inquiry report, may I read, Lordship? I have the honor to report that as per your kind endorsement, I have made inquiry on the complaint lodged by Rafiqul Islam, Bhimapara, South Salman, Assam. During inquiry, it is learned that the stolen vehicle and involved person were intercepted in Dhalai PS. That has already been recovered from the other accused, Lordship. Not
this person.
from me. But one Akhirul Islam has apprehended in this case.
Mhm.
He is neighbor to me. And this is the first bail application antecedent of the petitioner, Lordship. So I am ready to appear, Lordship. No notice was also issued to me till today. Vehicle has already been recovered.
Anything?
What is his apprehension of arrest, Lordship, after appraisal of the case diary, it will be revealed, Lordship.
I have stated in para number 3, Lordship, that one Akhirul Islam had already been apprehended in this case, and who is neighbor and friend of me, the police is after me, Lordship. I have already stated.
These ones are ones related to connection with South Salmana PS case number 150 of 2025. The gist of the allegation and the FIR dated 31/10/25 is that the informant's vehicle AS34C 0453 Mahindra pickup was found missing on the next morning after it was parked before in front of one shop in the evening. Full stop. Petitioner's counsel submits that the petitioner is not named in the FIR, and as per the inquiry report, the vehicle has been already intercepted and recovered, and one person has been arrested who happens to be the neighbor and a friend of the present petitioner, and therefore the police have also called him. All for the case diary, however, in the interim, 25,170.
28 one, Lordship.
28 one.
Hello.
Please, your Lordship. Lordship will kindly come to the FIR which your Lordship will find in page 11. May I read, my lord? Sir, with due respect, I would like to submit that on the morning of 12/9/2025, at about 6:30 AM, our co-villagers, namely Monwar Hussain, Abdul Sattar, Bandesh Ali, Moinuddin, Nuruddin, Akab Ali, Shohar Ali, Zuran Ali, and Surab Ali, went to the shore of Raukua RNDC Part 4 to cultivate black lentils in an area measuring 25 bighas of land. At about 8 AM, while they were engaged in cultivating the said black lentils, the below mentioned accused persons attacked them with deadly weapons such as lathis, daws, rods, swords, and other sharp objects. As a result, all of them sustained severe injuries. Among them, my paternal uncle Monwar Hussain, son of so-and-so, and my maternal uncle Sattar Ali, son of so-and-so, both residents of such and such place, were taken to Lokhipur Salient Care Hospital in critical condition. However, the attending doctor declared that both of them dead. The other injured persons are undergoing treatment. It is to be mentioned here that after the aforementioned incident, when our co-villagers, namely Akbar Ali Talukdar, Asad Madani, and Samsul Haq, attempted to intervene in order to save the injured, the accused attacked them as well, and consequently they sustained injuries. So 2 persons may not have died. This is not in dispute. Now, your Lordship will see the name and address of the accused persons. It goes starts from page 12 to page 13. They have implicated, my lord, name 27 people and with others, my lord. So every person from that family has been implicated. Now, in this case, the petitioner before your Lordship fairly submitting, my lord, he was there. Your Lordship will kindly come to page 26 and 27.
This is Amjad Ali, huh?
Amjad Ali, madam. Page
Page?
26 and 27, madam. Amjad Ali is a 64-year-old person. Page 27, your lordship will first see his
Oh.
condition, my lord.
Mm.
And page 26 is the certificate given by the doctors. So, my lord, when this incident happened, there was a feud going on regarding that plot of land, my lord, where this
He
cultivation was going
sustained
on.
his injuries.
He sustained an injuries
The
in
incident.
that fight. So when this fight took place, this person was attacked and this person sustained injuries and now rods had to be inserted for sustaining that fracture. My lord. So he sustained injuries and after he sustained injuries, this fight took place. In the course of this fight, these two persons unfortunately died. Your lordship, in this case, already one of the co-accused. One of the co-accused has been given interim protection by this honorable court. Musib Ali Sheikh.
There is a cross FIR also.
No, man, there is no cross FIR because
There's
this
no-
person, by the time this person regained consciousness, my lord, this murder FIR had already been lodged. So all of them apprehended that if they go and lodge an FIR, by the time they will also get
Can
arrested.
you just repeat this part? What happened was there was this fight.
This land was there, my lord.
Uh-huh.
This land, there was a dispute going on between these two families.
Uh-huh.
So on the day of the incident,
Uh-huh.
when this land was being cultivated, so a fight took place between both the families.
So allegedly, this petitioners,
This
these
petitioner,
persons, they attacked.
the petitioner is named as one of the persons in a group of 27-28 people
Okay.
who had allegedly attacked the victims and two of them died. Now petitioner before your lordship admits that he was present there. He was attacked. He sustained this fracture
And
injury, my
there
lord.
was an attack from the other side also.
From the other side. In the course of that attack, this person sustained this fracture, my lord. And he is a 64-year-old person, my lord, has seen his condition from the photograph also it is apparent. Now, that, whatever be the cause, my lord, that is not in dispute, my lord, that has definitely occurred, my lord. The role of this person who himself is a victim of a grievous assault, my lord. That is something which your lordship will examine.
Yeah.
But considering his age and his condition, my lord, perhaps if your lordship considers, since already one of the co-accused has been granted interim protection. Because he has been granted protection on the plea that on that day of occurrence, he was not present.
This one.
This person.
The rejection order of 24, lordship, is 24.
It said only, interim has to be given only on the ground it has to be given.
Yes,
So
sir.
with age and especially the injuries, more than the age actually. Otherwise, there were as many as, double homicide. Persons have died.
2 persons have died.
Anyway, so. Second and third paragraph was only transferred. The Nawaz Learned Council submits that there was a assault from the other side also, in which the petitioner sustained serious injuries. And in support of the same, my attention has been drawn to the medical document, as well as the photograph, which indicates compound fracture in the leg and with rods inserted. The petitioner is stated to be aged 64 years. From the photograph, prima facie, the condition of the petitioner appears to be quite bad. So, considering, call for the case diary, however, considering that aspect of the matter is directed in the interim, so it's 25,000 once year. Appearing is no point giving because I don't think he's in a
My lord, he's
position
in a
to
position
move.
to appear, my lord.
He'll cooperate with investigation. It will not be practical. Not hamper or temporary. This is the matter on
28-1.
I'm deeply aware.
Happened, Lordship. The 438, sorry, Lordship, anticipated bail application, Lordship. The second bail application, Lordship, earlier the bail petition was rejected by this honorable court, Lordship. I have annexed the copy of bail order, Lordship. Page 43 is the order, Lordship. Though the bail application was rejected by this court, Lordship, from my important point of page number 53, Lordship, is the bail order. Though the though the bail application was rejected by this court lordship,
Hmm.
by some important point was not reflected in the order lordship. If there were lordship, the last working day of the 25-year lordship, that's why some important point was not reflected in the order lordship. That's why I have finally again come to before this lordship. What I'm going to submit lordship, that this case,
Just a minute.
there are two cases, one in Jorhat and one in CID case, lordship.
Okay. This is the CID case.
This is CID case.
Just before we go, will it be possible to get this diary also on tomorrow?
Let's try it.
We can try. That's news.
What, lordship, for a moment, lordship, in Jorhat case, lordship, already court has gone interim order, and thereafter, that interim order was absolute by this court, lordship. And this CID case, lordship, though the incident of 75 district was made in the CID cases, so far petitioner is concerned, lordship, though the Jorhat PS case reference was made in the CID case. That's my submission, lordship. But lordship may kindly come to the order, lordship. Page 55, lordship. However, the allegation of the FIR giving rise to the present CID PS case, apart from reference to these police cases, allegations have also been made about involvement of the petitioner in the extortion activities in a manner of organized crime. But so far as petitioner is concerned, lordship, Jorhat PS incident was in the CID case, lordship. Other accused is something different. They are already in jail, lordship. So petitioner is concerned, lordship,
The same, it is the same allegation.
same allegation, lordship. That's why I have ratio laid down TT Anthony versus State of Kerala. I placed before this court.
Okay, I can
Already
be,
in Jorhat PS, already court has granted bail. I appear before the investigation authority. I complied to all the conditions imposed upon by this court, lordship. So this case is a not maintainable, lordship. So petitioner is concerned, lordship.
can you give me an order, copy of that order, Jorhat order? Is it passed by
I
High
have
Court?
annexed, lordship.
You have annexed.
I have already annexed, lordship.
But anyway,
Lordship will find page 37.
let us try the case diary. tomorrow. Try to get it. I can be wrong also. No.
Page
Why not?
40 is lordship,
Fine.
lordship one interim order, lordship, page 40, lordship. This is a order passed on 8/10/2025, interim order, lordship. And thereafter, lordship, this interim order, after absolute made on 4/11, after perusing the case, their lordship. And why the court has granted bail? Because this is the only demand part, lordship. They have not received any single penny, lordship.
Anyway, I'll see it again.
So some protection may begin. Bihu is also coming, lordship.
Tomorrow, we're fixing it tomorrow.
How like, lordship?
Yes, go ahead, insurance. The learned counsel for the petitioner submits that in this case, the allegations in this case are similar to Jorhat PS case number 438 of 25, in which the petitioner has already got bail, and therefore, in a way, this this criminal proceeding is not maintainable. Also, it is not, it is also submitted, no, it is fairly submitted that earlier bail petition was rejected on 19/12/25. Asked by this court in AB 2986 of 25. Call for the case diary of CID PS case number 20 of 25. Let's tomorrow. Get it? You can get it. Guwahati.
Highly obliged, lordship.
Diary has come.
In this case, charge sheet submitted.
Charge sheet submitted. What is the allegation? What is the, where is the FIR?
FIR case number.
FI case, your lordship.
Okay. He's on interim bail.
Yes, lordship.
the petitioner heard so and so. Petitioner was granted interim bail, interim bail on 1/8/2025. Case diary was called for, but it is submitted by the learned prosecution. But in the meantime, upon completion of investigation, charge sheet has been submitted. We will make it absolute. In view of the same, the interim bail granted by so and so is hereby made absolute, subject to the condition that he shall be available for trial if one commences. Number 3, he shall not hamper or damper evidence. He shall not commit any illegal activities. Bail petition stands allowed and disposed of.
May I please you, Lord? At petition number 483, I am behind about 252 days. Case is not yet been charge sheeted. But just I have come to know from my friend that there was an extension order. Though I have got no knowledge, and my client from Silchar also did not inform me. So, my lord, this extension was to my submission. It was not done according to law. Our own High Court judgment by my Lord Justice B.D. Agrawala has said, when his historic judgment has said that a copy must be sent to the accused. He must be heard. In this, and my lord, the subsequent judgment also, my lord, there is a judgment of Tamil Nadu and other states. 14 days before of the expiry of the 180 days, we have to file an application. And
that has been said.
There are judgments of
14
like
days
that. I can produce, my lord.
14 days, I don't know, but
I've got judgment. I have got judgment.
Co-accused has filed application and his bail application was rejected by coordinate bench. Same ground was taken, that was negated by the court. Court held that they should challenge the order of extension separately.
then that is what came to my mind.
Yes,
Actually. By criminal petition, that cannot be done.
Yes,
Extension, of course, the person can
But-
be aggrieved by the extension.
yes, he can.
Extension, it is, I think, Ravindran or some intelligence, central revenue
This
intelligence.
judgment is a latest judgment.
So, that
But my lord, the judgment passed by my honorable Justice B.D. Agrawala, there is no such condition that I have to go for challenge these things for it. In the bail petition itself, it can be considered.
No,
And
because,
it
without-
was considered.
No, since it has been extended, then the bail can be granted, on statutory bail can be granted only if it is held that the extension was bad in law.
Yes,
law
Lord,
effects.
that has to be, that order has to put under challenge also.
Anyway,
Now-
let me see this.
Now that my coordinate bench has laid down the condition that I have to challenge it. But the judgment given by my Lord Justice B.D. Agrawala, it was
Can
not
we-
there.
Can we see that order? Judgment? Violation of.
So, my lord, my prayer is that let there be hearing on this point, my lord. Whether I have to, I can file this petition is maintainable without challenging the order.
It can be a joint petition also, basically a 482 petition read with
Yes, Lord.
439, something like that. Then we can take up both anyway, so, or 482, let's say, 528 BNS.
Yes, sir.
That is filed and both are taken up together.
Yes,
It's a
that can be.
technicality.
Yes, Lord.
Both are taken up together. Anyway, let me read what
Then I have to file, my lord,
you have to file then, but they
challenging the order, but I don't have the copy of the order.
don't have, and time is also there, not there. But this point needs to be heard then. Or should it go before that coordinate bench?
Yes, Lord.
Huh?
As per Lordship.
Not
notice-
that, it takes.
No, well, it is not required, my lord. Your lordship can take a revision.
There is a notification to that effect by the registry.
No. If, with all respect to my learned friend, my lord, well, notification is there, but provided it is rejected, my lord.
It is rejected.
Rejected, my lord, but now we are challenging the maintainability of the extension.
It is
No,
not
that
there.
is what actually this coordinate bench has said. So, in a way, if I depart, then it will be two contradictory views on the law point. No, bail is different.
Bail is
One
different. That
bench,
is,
ideally, one FIR, one bench is better, but still, that's a difference. But since the coordinate bench has kind of taken a legal position,
Not-
Exactly.
not a routine bail rejection,
Yes,
yeah,
yes.
that's different. Legal position, if I depart, Actually, if, and I say that, then it would be
That
like
is-
holding something contradictory. Ideally, if I disagree, it should be referred to
Lordship,
larger bench.
to Lord Seven.
I think instead of wasting time, you quickly file a petition.
Yes.
That will be better.
Yes.
Why waste time? And anyway, it can be taken up together.
Well, 7 days time, maybe I will file it.
Yes, fine. But the only thing is the intervening holidays. Can't help. Mr. Biswas.
Next case,
SC
yes.
Kayal, assisted by MD.
এখানে একটা
The petitioner is seeking bail. uh, With regard to NDPS case number so and so. He is in
Okay.
custody since 2/5/2025. The statutory period was extended up to 180 days.
90 days, Lord.
Up to by another 90 days. By order dated.
27/10/25. 27/10/25.
27/10/2025. The primary contention of the petitioner is that the extension was made without hearing the petitioner as accused. Therefore, the same is valid in law and he should be granted bail. Relying on a order dated 2011/2025 passed by coordinate bench of this court in BA 3266 of 25, learned prosecution being the customs department contents that in that order, the coordinate bench has held that in the bail petition, the court would not be able to go into the merit of the extension without the same being challenged. In this facts and circumstances, Mr. Biswas, learned counsel, seek some time, praised that the bail petition may be kept pending, and in the meantime, perhaps a criminal petition would be filed to challenge challenge the extension order. And perhaps both the matters can be taken up together. Prayer is allowed. List matter on
After 2 weeks, man.
after 2 weeks.
Weeks.
This is the matter after 2 weeks.
After 2 weeks.
We file it and then we'll tag it to the.
13. 12 kunta. 12 kunta.
My lord, can it be taken up after some time?
After some.
After something. Obligation.
My lord, in this case, they have filed one objection against my bail, my lord. The case has not yet been charge sheeted.
Okay.
Statutory period is already over.
Charge sheet has been already been filed on 30/12/2025. Lord.
We have no knowledge, my lord, these things.
T12.
But that is also
The-
extension has been given.
Yes.
Huh?
Yes.
Here also extension, we have challenged it, my lord. This is extension period. Under revision, we have challenged it.
Yeah, you filed a criminal petition.
Yes,
Both
and
the both the application may be heard together, Lord.
No, it seems so. Same thing has to be done. Immediately after reopening.
Lots.
Yes.
As per your
yes, yes.
mutually convenient date. Stuff. Heard. Let's see this off and same number. I told you, originally clear. The petitioner herein is seeking bail in connection with NCB case number 5 of 25 under so and so section. He was arrested on 7/4/2025. Stuff. It is submitted that in this case, extension of the statutory period was granted, which has been challenged by separate proceeding. Case diary has been.
Lordship,
you
final
case diary?
complaint, if required, I'll produce the evidence.
Okay, the prosecution / NCB has filed a
Case number
reply.
2.
The case diary may be produced.
Or Lordship LCR may be called hold
Ah.
since we have filed our.
NDPS case number
The case diary along with the charge sheet. Scan copy.
You
Take
know,
a
NDPS case number one
lot
twenty-three
of time
twenty.
it will take. Scan copy, should I call?
Yes, same
Take a
copy.
lot of time. Of NDPS case number
12325.
123 of 25 from the court of the learned
Lordship Sessions, Assistant Judge Silchar Lord.
Session Judge Pilcher, along with the comprising case diary and charge sheet. Stop. This matter after 2 weeks.
Not.
After 2 weeks. Do you have the number of that?
Yeah, I have just correct.
No, this the challenge petition.
No, I will give you one. We have filed it, I will give it.
But it did not number yet to be make it.
But we have filed before vacation, my lord.
Much of
I'll not say anything. Tag it together after that. It's after 2 weeks.
My lord, may I please your lordship, my lord? This is a 483 application, my lord. I am 178 days behind the bar. The FIR is at, my lord. I take your lordship to kindly to come to FIR. A very peculiar case, my lord, but court is not, page 13 is the FIR, my lord, kindly. 1-3. My lord, you have got it, my lord? Got it, my lord?
Hmm.
My lord, it is respectfully submitted that on 25/4/25, at about 9:30 p.m., my husband went out for the house to catch fish from the river, but till the next day morning, he did not return. And as such, my husband's elder brother, daughter, namely Rabina Begum, and my husband's elder brother, Babur Ali, had started to search my husband and found my husband lying dead near Rani Mill. His entire body was full of injuries and his head was also having a cut injuries. That about 11 above the named accused person is a dangerous character, cheater. I and my accused person were studying in the GC college since 2006 and we are known to each other. By the way, we have developed a relationship and our affairs started and accused used to visit my house often. That on 26/4/25 at about 11 a.m. I had identified the dead body of my husband. I therefore pray most humbly that your honor may be take necessary action. Now, my lord, this is the allegation. My name is not in the affair, my lord. Only that her husband went to the river to catch fish. Next day, her dead body was found
About
with injuries
11,
mark.
11 above named accused person. What?
Yes, above there is no more name, my lord. Above there is no.
Above named accused person.
Yes.
But no one is named.
Then, my lord, I said the case was charge sheeted, but medical report is very interesting, my lord.
Just a minute. There was she mentioned stated about above named accused, but no name has been.
No name is.
No, page number 15, my lord.
What is this?
How it is above then?
Page number 15, my lord. Lordship may kindly come to below portion, my lord.
Mohoday.
Mitoder Bornona, my lord. Down below, my lord, second line, my lord. মৃতদের বর্ণনা নাম আসাদ আলী বয়স অনুমান 50 বিবাহিত এবং এটি সন্তান
No, মৃতদেহর বর্ণনা. Dead body is
Victim's name.
victim.
Acha, any
Now, my
medical report? Where is the medical report?
Yes, medical report kindly peruse, my lord. Page 34. The opinion regarding the cause of the death is kept pending till the report of chemical analysis comes. 178 days. Charge sheeted. And my lord, your lordship will be surprised to know the scan copy has come. There is no name of all the witnesses have never implicated this person. And she suspects that there was a love affair during her current life and she might have killed her husband. Medical report does not reflect anything. Then, my lord, again, I take your place 36. Place 36, my lord. No poison was detected in exhibit number such and such. He did not die because of poisoning also. So, my lord, I am ruling to face the trial, my lord. My detention may not be required, my lord. 178 days behind the bar. I pray for bail for any condition, my lord.
No, I'm trying to correlate this the observation regarding the dead body
Yes,
with the allegation regarding the injuries.
nothing.
That
Conditions are
Dr. will
there,
find in page number
conditions.
31, my lord.
Conditions,
Page number 31, my lord.
31. Three different condition
Yes, my lord.
present over peritotemporal region.
Yes.
Diffuse contusion over right temporal region. Bone congestion. Brain congestion. Sorry. Cut injuries is not there. It's
Not there.
And as well, page number 30 also, my lord, down below, my lord.
Hmm.
Page number 30, last two line, my
There
lord.
is also peeling of skin. That is due to decomposition. And right FA. There are certain medical terms. Contusions on the right. Contusions on the right side. The witnesses have not implicated.
No.
So.
And kindly peruse the evidence portion, 161 statement.
You won't spend much time, just quickly. Unnecessary documents also come, no? This when you
Yes.
call for that. That's why I've started specifying. All we need is this case diary and these are order sheets. Can you have a look? I could not
My lord,
find
I have gone through, my lord. In this
Statement-
case, my lord,
statements of witnesses.
witnesses are there, my lord, and lordship may also may peruse the statement of the accused person, although I'm not relying, my lord. Because there was, my lord, some, my lord, argument, my lord, before the incident, my lord. And on the day of incident, my lord, both the, my lord, petitioner and the accused person, my lord, they were fishing in a nearby pond, my lord. Then the incident occurred, my lord.
But you.
My humble submission, my lord, charge has already been framed, my lord. 7 witnesses cited in the charge sheet, my lord. Let the, my lord, informant be examined, my lord.
My lord, whether your lordship will peruse the evidence, my lord, of the 161, or it justifies my detention.
At this stage, my lord, this is not a, my lord.
151, no implication.
No evidence,
161
nothing.
direct implication, nobody has seen, my lord.
Then my lord.
Circumstantial. He has.
These are the
he has-
circumstances, evidence,
His
my lord.
own statement, he has self-implicated.
Self-implicated.
Incriminated.
Nobody has implicated.
No, he has himself.
Accused is implicated himself.
Anyway. There was a
At this
quarrel
stage,
and
my
then-
lord,
Quarrel, that is,
Yes.
that presumption is that because of the quarrel, he might have killed my brother, son.
at this stage, my lord, only, my lord, what are the prima facie materials, my lord, for which, my lord, charges has been, my lord, charge sheet has been submitted and charges are framed, my lord. That has to be looked into, my lord. Otherwise, my lordship, at this stage, my lordship cannot, my
But
lord,
if there is no
go into the,
implication
my
in the
lord.
statements of the witnesses, then even
Yes.
framing of charge, anyway.
Charge has been framed
We
already.
have also challenged that charge also, my lord, before the Honorable High Court.
I won't be able to take out.
Yes.
Because I have.
So, my lord, I'll,
Almost
any
expressed in
petition, I'll appear, I'll face the trial.
Generally, a person will be aggrieved if the
Yes.
statements are not implicating and charge is framed. There has to be some other materials, of course. The ST Biswas and RJ Bolo, the petitioner seeking regular bail in connection with Sessions case number 204 of 25. Pending before the learned additional session judge Sribum Karimganj. Full stop. FIR was lodged by
Champa Begum, my lord.
on Champa Begum on
On 1/5/25.
1/5/2020. No, on 34, honey. Please, sorry. 34/2025. At the Kaligans outpost, whereupon Karimganj PS case number 205 of 25 was registered, which after investigation was charge sheeted, leading to registration of the aforesaid Sessions case. It is submitted, a charge have been framed and examination of witnesses is pending. The accused was arrested in this case on 15/7/2025. It is submitted that the scan record has been received. It is submitted that the witnesses have not implicated the petitioner. The prosecution does not dispute the same and submits fairly that there is no direct implication in the statements of the witnesses, and also submits that there are no eyewitness to the occurrence. Full stop. It is pointed out by the prosecution that the statement of the accused himself is self-incriminating. The prosecution objects to the bail at this stage. On the other hand, the petitioner counsel contents about the length of detention. I've given my consideration to the matter. Keeping in mind the fact that there's stated to be not much direct implication in the statements of the witnesses, and also the fact that the accused has been in custody since so and so date, 15/7/2025, and trial is poised to begin. Therefore, it might be prudent. It may be fair, prudent. It may be fair to grant him bail at this stage. In such view of the matter, allowed to go on bail of rupees 50,000 with one surety of the like amount, the satisfaction of the concerned learned court, additional session judge Sri Bhumi, and subject to the condition that he shall be available during the trial. Number 2, he shall not hamper or tamper with evidence. He shall not try to influence or intimidate or harm the informant or witnesses. Violation of the bail conditions would make the bail liable to be cancelled. Bail conditions allowed and disposed of. At a line, nothing stated here in this bail order shall be taken as expressing any view on the merits of the case, in trial, to the prejudice of either the defense or the prosecution. Okay, all right.
Bail application, there is an office note of 5/1 stating that the service is awaited on the respondent number 2. Yes, ma'am. On 19/12, when the matter was listed, on instruction, learned public prosecutor submitted that the notice has been received by the learned, that by the investigating officer. It was the delivered to the informant on 19/12. Same position has been sold to them.
The service report, my lord, we have not received, my lord, whether it is served upon the informant or not, my lord.
That IO has received on 19/12, the public prosecutor has submitted on instruction.
It's another
Otherwise,
court.
all the
It was
witnesses.
for another bench. It is written
My-
like this. The learned additional PP has submitted that service report is awaited. It's written
Awaited.
like that.
No, on the orally she submitted, my lord.
It's written. Office note says that it is awaited.
It is awaited. Otherwise, my lord, all the witnesses has been
At
examined.
best we can take is, you can take instructions
My lord,
in the
that is,
course of the day.
my lord, not possible, my lord, let it come tomorrow, my lord.
Tomorrow, my lord.
Tomorrow actually, no problem. But tomorrow, again, will be overloaded.
My lord, today, my lord, we have got several matters, my lord.
Yes, I understand. Tomorrow also you'll be very busy.
My lord,
Tomorrow
tomorrow,
at 2 PM, my lord.
It's okay, no problem. I cannot feel that there's so many matters.
Yes, ma'am.
2 PM, there has to be a specific reason.
My lord.
Uh,
Oblige.
The prosecution can take instructions regarding the service upon the respond number 2/informant. List the matter tomorrow.
My lord.
Tomorrow I'll finish all bits, I
Yes,
assure
my
you.
lord, my lord.
Today also.
It is a lot of petitioner behind the bar since 10 months or shift due to NBW issued against Stephen Lordship.
Foxo,
Lordship.
you have appeared? Madam, you have appeared?
Yes, I'm
For
from
the informant?
Amicus. Sir.
Amicus.
Yes.
Yes, sir. Go ahead, please.
Lordship. The rejection page 55 Lordship.
He's in, from March, he's in detention. This victim has been examined,
All, total 10 witness lordship, all are examined.
all examined.
All are examined.
Lordship, my lord, may peruse the order dated, my lord, 2/5/2025, my lord,
Of this court.
of the scan copy, my lord, scan copy, my lord. That I have flagged it, my lord, 2/5/2025, my lord. Why he was taken into custody, my lord, again.
What is the, okay, victim had raised some objection,
Yes, my lord.
but anyway, objection can be raised, but the objection has to be decided, right? That why bail should not be granted, either agreeing or disagreeing, or partly agreeing, partly, something like that. Anyway, so otherwise, if all witnesses are examined, then it is at the stage of judgment. probably.
Wonder whether all witnesses are examined or not, that is not clear from the record, my lord, because at this stage, my lord, this is the old, my lord, scan copy, my lord. This present, up to this scan copy has not received, my lord. So as per the, my lord, last order, my lord.
See, the victims.
PW 10.
Page 37 is the PW 10, Lordship.
37?
Yes, Lordship. He was examined on 2nd August 2024.
PW 10,
Yes, Lordship. There are 10 witnesses,
all are examined, it seems.
all examined, but Lordship, the trial court again fixing the case for PW's, Lordship, again and again. And he was earlier also granted bail, and thereafter he was taken into custody again, Lordship. Thereafter his bail was rejected. Mm.
There are some in the modification.
There was some agreement was also executed once between the families for her marriage, something. Anyway. Otherwise,
Otherwise, he is, since long, he is in the jail.
that's true, but if the
Period of
indications
detention.
and this eviction, then again you'll have to.
And
but
victim
anyway,
and informant were already examined.
Heard. R. Chaudhary for the informant. Asad, Suleiman and Burwa and Amicus, by the way, Amicus. Invoking 483 BNSS, the petitioner seeking bail, regular bail in connection with Agribari PS case number 127 of 2021, which after completion of investigation was charged sheeted and resulting in special case number 38 of 21 under section 376 IPC, read with section 4 of the POCSO Act. Accused is in custody since 21/3/2025. Scan copies received. Stop. 10 witnesses have been examined so far, including the alleged victim girl, an informant also, right? Informant has been examined. Informant. However, it appears that prosecution evidence has not yet been closed. Considering the progress of trial and the length of detention allowed to go on 50,000 with 1 year. That additional condition, he shall not in any manner cause any harassment or harm to the victim girl. Violation will entail cancellation of the bail. Allowed in this post. Yeah.
Applies.
Allowed. 50,000 with 1 year.
The petitioner is in custody for 63 days, Lordship, and your Lordship will find at page 8.
Page 8.
Page 8.
Would you like to read?
Respectfully begs to state that the above named accused person got married to my sister Hamida Begum approximately 3 years ago, according to Muslim Shariat law. After few days of their marriage, the accused person tortured my sister both physically and mentally on account of demands of dowry. On several occasions, the disputes and instances of assault between husband and wife were amicably settled by the elders of their village. At present, they have one 13-month-old daughter. On 4/11/2025, at about 8 a.m. in the morning, the accused person informed me over telephone that my sister's health condition is serious, and for that they brought her to the hospital. After some time, the accused again informed me over telephone that my sister expired in the Karimganj Civil Hospital. Immediately thereafter, I, along with my family members, arrived at the hospital and found the lifeless body of my sister. As a result of which, we strongly suspect that the accused killed her and then brought her to the hospital. It is mentioned here that the accused person repeatedly demanded dowry from us. However, we were not in a position to fulfill his demands. On the earlier occasion also, the accused threatened to kill my sister. There was a delay in lodging the FIR as we were busy with immediate arrangements and formalities relating to cremation of dead body. So this is the FIR, Lordship, and from the FIR itself, your Lordship will see that they took the victim to the hospital, Lordship, and they were in constant touch with the informant. They were giving him the information, Lordship. And only because she died, thereafter the present FIR has been lodged only on suspicion. And presently, Lordship, the 30-month-old daughter is also there, Lordship, and 63 days in custody. Prior to this, Lordship, no FIR was lodged regarding torture, Lordship, and no specific date is mentioned here also. General allegation is made that dowry were demanded and non-fulfillment of that, because of that, physical and mental torture was caused. But no specific date or month or year is mentioned, Lordship, by the informant. And the grounds of arrest, your Lordship will find probably, Lordship, page 15. These are the general grounds which normally police gives, Lordship. And then number 6, they said sufficient evidences are found against him. So if already evidences are found when 63 days in custody, further custody probably may not be required, Lordship. Everything has been recovered and medical evidence will reveal everything. And for that he cannot tamper, Lordship.
Case that is not received, my lord, that is why.
Not received.
Not received, my lord.
Already 63 days in custody, Lordship, and 13-month-old daughter is also there,
That will be
Lordship,
necessary.
considering that aspect.
That will be necessary in this case. You would agree, you'd also agree. So,
Wait, this take an argument, this.
19th, maybe, on reopening.
Well, on to 20, my lord.
20.
20.
We fixed a lot of matters, Mr. Bora, on 20th. I don't know what is the
My
number, but please keep a
Yeah,
track.
21,
that
my
also.
lord.
The
21.
21, we fixed a lot of matters. More than 19 and 22, maybe we have some space. To solve.
He is in custody, considering that Lordship may fix on 20, Lordship.
20.
20.
Yes, no. The case diary of Sri Bhumi TS case number 483 of 25 has called for not yet receipt. Accused is in custody since 7/11/2025. In connection with this case,
30.
which was registered
30, लिखिए सुनो.
on an FIR lodged by the brother-in-law of the accused upon death of his sister, within bracket, wife of the accused. Is the matter on this?
21, man.
220.
20, man.
How like it?
Seventeen. Diary?
Wait, this is
Case diary not received, my lord, 17.
around 88 days in custody, Lordship, as on today. And long vacation is also.
What is the allegation?
Allegation 109 is there. Lordship, you kindly find the FIR at page 9, relevant portion, page
My lord,
12.
tell my lord, we take instruction, my lord, whether investigation is pending or completed, my lord. It will be after at 2 p.m., my lord.
Second half.
Second half of it.
Obliged.
15, 18.
May I please your lordship? CD was called for lordship.
18.
TDS come.
Three received, Lordship.
No, no, I am behind the bar since 52 days, lordship. And all the materials already been recovered, lordship. Further custodial detention may not be necessary, lordship. Kindly at any finding. FIR is at page 14.
Yes. Page 14.
And I am not FIR name accused person, Your Honor. An informant suspected his driver along with his associate, but I don't know the driver of the informant, Your Honor.
Yeah, Lordship, main accused is other person, is Nasiruddin Ali. He is the main.
He was the driver. This person was the
He was
driver.
along with him, Lordship.
He was along with him.
Along
He
with-
was the driver, Nasiruddin.
Driver, and he has hired theft. Hired theft that always he was hired for thief any any particular area or go down or any premises, Lordship.
Saidul Islam, lordship.
But he was along with him, Lordship. On that day, he was taking alcohol with that company campus, Lordship, from the go down. And he,
I am a worker under Tower Construction Company here. 52 days, lordship, 60 days offense.
Equal it, learned counsel, and DP Goswami. Bongaigaon PS case number 292 of 2025. Arrested on 17/11. The allegation was lodged on behalf of one GB Construction. The gist of the allegations was that one Bolero vehicle was carrying materials driven by one Manoj Pratim Dora, but subsequently it was missing, and thereafter it was recovered. Stop. It is alleged suspicion has been cast in the FIR regarding the said driver and involvement in theft of the vehicle along with and materials in association with other people. The present petitioner is not named in the FIR, right? Not
Yes.
named in the FIR, and it is submitted with the learned counsel submit that he is a he's a ordinary employee of the firm and not at all connected with the alleged offences. Case diary has been received. The learned prosecution fairly submits that the main allegations are against this. Allegations are against
Nasiruddin Ali.
Nasiruddin Ali and Manoj
Pra-
Pratim.
Manoj Pratim was there, Lordship. After investigation, it was
Ah.
revealed that Nasiruddin
Main
Ali.
allegation,
Yes.
the main materials upon investigation has been found with against another person rather than this accused. Considering that aspect of the matter also and also length of detention is allowed to go on 25,000 pounds. Satisfaction. Shall cooperate remaining investigation. Not
Obliged.
for temporary. So return case diary disposed. Disposed.
May it please your lordship. In this case, the applicants, my lords, they are brothers, my lord, and my lord, they are in custody, my lord. Applicant number 1 from 172 days, my lord, and applicant number 2, my lord, 171 days, my lord. The allegations, my lord, is page 10, my lord, FIR is basically dacoity, my lord. And lordship may kindly come to page 13, my lord, once. Page 13. Dacoity has been conducted, is a charge sheeted case, my lord. Already charge sheet has been submitted, my lord. So, my lord,
TCR received, Lordship. It was gone for by Ranjan Borwa, Lordship. I informed him to come, Lordship.
so my lord, at page 13, my lord, this is an FIR, my lord, where the 5 persons were involved in the incidents, my lord. So, my lord, the robbery has been committed, my lord, and dacoity has been committed, my lord. Thereafter, the petitioner was arrested, my lord.
Let us see the forwarding report.
Yes, my lord. Lordship may kindly come to, my lord, prior to that, my lordship come to page 15 once, my lord. This is the arrest memo of applicant number 1. If lordship sees, my lord, there is a apparent violation of 36, my lord, because there is no witnesses of the person of the family members or the locality of a person, renowned person of the locality, no witness, my lord. At page 16, lordship may kindly see. Page 15, my lord. 16 is the last part down below. Normally there is a witnesses, but in this case there is no witness given, my lord. And applicant number 2 also at page 17 is the arrest memo. So it also shows that no witnesses, my lord. No signature attestation of the witnesses, my lord. Now I will take your lordship to page 19, my lord. So, my lord, 4 persons have been arrested, my lord, on that day, my lord. And my lord, he was forwarded, my lord. And my lord, lordship may kindly see, my lord, that page 21, my lord, that 4 person forward. One, my lord, Bapi is the applicant before lordship. My lord, applicant, this Tuton Das, my lord, he has already been granted bail by this honorable court, my lord. Yes, he is the main accused, my lord, Tuton Das, my lord. So he is the mastermind of the entire conspiracy, my lord. He has been granted bail. I will produce the order of to your lordship, my lord. Thereafter, lordship may kindly see, my lord, that thereafter charge sheet has been submitted. In the charge sheet, my lord, at page 41, it shows that only because of, my lord, CDR analysis, my lord, they found that applicant number 1, my lord, he on and after the incident, my lord, he was in contact with one Sontu Das, Sontu Paul, my lord. And that is the reasons for which, my lord, he has been shown as an accused person in this case, my lord. If lordship come to page 41, my lord, the down below, during the course of investigation, CDR analysis of accused Bapi mobile number so-and-so was conducted. It was found that he had made several contacts with mobile number so-and-so. On verification, the said number was found to be used by habitual offender Sontu Das, both before and after the day of occurrence, including during midnight. So ultimately, this is the reasons for which, my lord, this Bapi Paul has been, my lord, apprehended, my lord. He was arrested and he was made an accused person. So as on today, my lord, is almost, my lord, 170.
What is the stage of the case before?
My lord, charge not framed, my lord, and my lord is fixed for appearance, my lord. So, my lord, I will just produce, my lord, because one order, my lord, of this honorable court, my lord.
This is a serious case of dacoity, organized dacoity.
Yes.
Let him come, make his submission and he will submit.
Okay.
Yes.
Laura is looking into it
After some time.
After some time.
After some time?
Yes.
Item number 25 may also be taken together in the out of the same FIR.
Okay.
25.
Item number 20.
Yeah, only who said, I'm like that.
May I please your lordship? Lordship, it is a regular bail application, lordship, today fixed for the city, lordship.
You have not received the case, right?
Lordship, as per my information, lordship, search sheet was filed, lordship.
Just a minute, sir.
Equivalent number of such. Such number 9.
Lordship, I am in judicial custody for more than 45 days, lordship. Lordship, FIR himself reveals the fact that I am in a love relation with the girl, lordship. Lordship, I am just 22 years old, lordship. Lordship, lordship, and I am the breadwinner of my family, lordship. Lordship, my father already passed on, lordship.
Just a minute. I'll come to you. I've heard you. There is not received, right?
Not received. Victim is a minor one.
Minor, yes, sir. 17 years. It appears to be a case of elopement. Heard your good name?
Mr. R. Patel.
And the Rajyotishpur PS case number 157 of 25. The accused was arrested on 23/11/2025. Good stuff. It is registered under 87, right?
87.
Yes, Lordship. The FIR alleges that the informant's daughter, aged 17 years, ran away with the accused petitioner herein, who's also the neighbor, their neighbor, and there's a love affair between them. As for the order of learned court below, as well as the forwarding materials, the girl has been recovered and stated to be aged 17 years. She was also forwarded to the learned magistrate. Her statement was also recorded before magistrate. The learned prosecution points out that the victim is below, this is not a, is a minor. The case diary, however, is not received. Prima facie, the alleged incident appears to be a case of elopement pursuant to love affair, though the girl is aged below 18 years. Issue reminder for the case diary, however, in the interim, the accused is allowed to go on bail of rupees 30,000 with one security of the like amount to the satisfaction of the concerned learned, subject to the conditions that he shall cooperate with remaining investigation, not hamper temporary residence. He shall not harass, intimidate, or harm the victim girl in any manner. Violation will entail cancellation of bail. Leave the matter on, it's not disposed of. I've granted in interim bail on list 29. In the meantime, we can go on bail. Just a break.
Ending at 65.
65.
Late result also. Madam, this is an anticipatory bail application, madam. FIR is at page number 16, madam. 16, madam. May I read the FIR? সন্মানপূৰ্বক বিনীত নিবেদন এই যে আজি 4/12/2024 তাৰিখে নিশা 1মান বজাত নিম্নলিখিত পদকীয়াই ঘৰত কোনো নথকাৰ সুযোগ লৈ ঘৰৰ বাউণ্ডেৰীৰ ভিতৰত সোমাই থাকে। মই প্ৰসাৱ কৰিব ঘৰৰ পৰা বাহিৰত ওলাওঁতেই পদকীয়াই মোৰ মুখত এখন হাতেৰে সোপা মাৰি ধৰে আৰু আন এখন হাতেৰে চুৰি লৈ মোৰ ডিঙিত লগাই দিয়ে। মই চিঞৰ বাখৰ কৰিলে ডিঙি কাটি দিম বুলি ভাবুকি দি ঘৰৰ ভিতৰত গৈ মোৰ লগত জোৰ জবৰদস্তি যৌন সংগম কৰে। মোৰ 1.5 বছৰীয়া পুত্ৰ সন্তানক বিছনাৰ পৰা মাটিত পেলাই দিয়ে আৰু মোৰ ডিঙিত থকা 1 ভৰি ওজনৰ সোণৰ চেইন এডাল কাঢ়ি লৈ যায়। So this FIR, my lord, was registered under 329(3), 329(4), trespass, 64, rape, and 351(3). Basically, it's a case of traditional FIR. But the thing is that the petitioner as well as the victim, they are both measures, they are both married. They were having a relationship outside their marriage, consensual extramarital affair was going on. And on this day, my lord, her husband and family members happened to found out their relationship. And thereafter, my lord, she was forced to lodge this FIR, my lord. Basically, her age is 22 years, of village Baukher Kuti, accused is of the same village, my lord, same village. And he is also major, both are married. And they were having some extramarital affair, my lord. Their parents and my lord, the local villagers discovered this relationship and she was forced to lodge this FIR. That is the case.
That's a appraisal of the case record and 180 statement of the victim was taken and that order of the rejection order of the on a trial court proceeding. So 180 statement, appeal materials are there in the case diary. So appraisal of the case diary, it is
180 statements, she will definitely reiterate
What is
whatever.
the motion?
it's a motion matter. It's a motion matter.
One,
Let him appear, my lord. Let his version of the story, my lord, come out on record, my lord. If there are eyewitnesses, my lord, their statement will also come, my lord.
Otherwise, prima facie, it is serious. Right? On the face of it is serious.
Yes,
If there is something else behind it,
Yes,
as you have said,
yes,
then it's a different matter.
yes,
That we don't know. Actually.
yes.
That
Let him appear, my
Your
lord.
instructions are the only.
Yes.
Yes, that's land council and DP Goshen. 482 bail application, Agomoni PS case number 108 of 25. And that's why the alleged victim girl herself lodged a fire dated 4/12/25. 24.
24.
So long time.
Yes.
24 with the allegation that on the same day, in the middle of the night, while she had gone to answer nature's call, the accused petitioner trespassed and after gagging her, committed rape upon her. And also took away gold chain from her neck. The petitioner counsel submits that the FIR is concocted and false. Is submitted that the fact of the matter is that the petitioner and the victim woman were having an illicit relationship. And when it was found out by her husband's family, he was compelled to lodge this false FIR against the petitioner. Sometimes, this kind of rape along with snatching away of the gold chain, it may be true also. But sometimes this can raise some questions.
But this might not
Rape-
language, my lord.
Not satisfied with the rape, he took away the necklace also.
This language, my lord.
This kind of things, sometimes.
Sometimes is true.
Uh,
Mostly, my lord, they are hiding. Accused always is hiding, my lord. At that point of time, he goes out.
What I'm trying to say is that sometimes this kind of thing, it may be, if it is true, then it has to be written. But if it is written just like that, even if the main accusation is correct, it can dilute it.
Yes.
Sometimes throw some doubts.
Right.
Anyway. The victim is stated to be 22 years old. Call for the case diary from the concerned police station, however, to enable the petitioner to record his version of events. In the interim, it is directed 25,000 advance. Usual conditions are extra. He shall not in any manner harass, harm, or intimidate the victim. This is the matter on
29-1.
29.
Highly obliged. Highly obliged.
Charge sheet submitting this photo.
Very long FIR. What is?
It's about commercial quantity 22C is there.
My lord, 179 days today, my lord.
NDPS case.
NDPS case.
Nice. Commercial quantity. Then we have to see. Then we have to-
75 boxes of the capsules containing 6 strips, 10,800 capsules.
The petitioner was arrested on 13/7/2025. No. They were arrested on different dates.
My lord,
Different dates, right?
1 and 2 arrested on 13/7
Huh.
and petition number 3 on
Petitioner
24.
number 1 and 2 were arrested on 13/7/25 and petition number 3 on 24/7/2025, in connection with Lakhimpur PS case number 80 of petition under so and so section. As one of the penal provision pertains to commercial quantities, therefore the applicability of section 37 is to be seen. The prosecution submits that. In the meantime, charge sheet has also been submitted. So we have to call for the case diary and charge sheet.
But it will only a charge sheet and case diary will be there, Lordship. Otherwise, the proceeding on is submitted on
Yes, no, we have to see
3/12/25.
37. We have to see 37, right?
Yes.
37 has to be seen. So for that, we'll need those materials, right? Or you approach the trial,
Approach the
court,
trial.
or should I call for the,
My lord may call for, my lord.
call for the scanned copy of the case diary and charge sheet? For such adjudication. This is the matter on
My lord, 19.
It is 27. 27 on Lordship.
27.
27/1.
Public.
May it please the lordship. Well, this is the second application, my lord. Earlier it was rejected, my lord. Page 10 is the FIR. Now, my lord, we have come up on 3 counts, my lord. First one, length of detention, my lord. Today 56 days. Page 10 is the FIR, your lordship.
Diary has come?
That has come.
But page 10 is the FIR, your lordship.
Yes, yes.
But here, my lord, the reading of a FIR, my lord, does not suggest that any commission of any offense, my lord.
Preparation for the.
A preparation of dacoity, my lord, but no guns, nothing, knife, anything has been recovered from some, my lord, uniforms. And other, my lord, things have been recovered from their possession, my lord.
Last reject, you see the program, investigation
My
after
lord,
8,
last
12.
is the rejected,
8/12.
more than a month ago, my lord.
I think the prosecutor see
8/12, it was
what is the
rejected.
present position.
8/12, it was rejected, my lord. And my lord, and another ground, my lord, filed one additional affidavit, my lord. His wife is in an advanced stage of pregnancy, my lord. Good, but affidavit, yes.
Only investigation is the name he has stated, the petitioner Lordship was involved in this preparation Lordship. They are yet to be arrested. Please search them, but not find in their house Lordship. And the last look at the IO, the objection pair is that 7/1/2006.
No, regarding that objection, lordship has rejected it earlier, my lord. Expected date of delivery is on next month, my lord, 19th of 19/2/26, my lord. That is page 39. In a very advanced stage of pregnancy, my lord. If there is something, we'll face the trial, my lord. So 56 days in custody. And my lord, the petitioner had also an
How much it has progressed?
In his confessional statement, he has stated some names, names of the.
No, after 8/12, it has progressed to some extent.
Only searching was going on for that
Okay.
co-accused person.
Earlier bill petition, this is a subsequent petition. Subsequent petition, earlier bill petition was rejected on 8/12/2025. In BA 3800 of 25. Heard star SM Abdullah, BP Goswami, para 2-3 million. Full stop. The case, the updated case diary was called for again and received. Full stop. Is submitted by the learned prosecution that investigation has progressed and it appears to be pending mainly for the apprehension of some other accused. Stop. The petitioner side has filed an additional affidavit along with annexed medical documents regarding advanced pregnancy of the petitioner's wife with due date stated to be on 19/2/2025. The length of detention as on today is also pointed out. Considering both the aspects, considering the aspect of progress of investigation, length of detention and the needs of the petitioner's wife, dash the petitioner, I accept this subsequent petition and the petitioner is allowed to go on bail of rupees 50,000 advance security to the satisfaction of the concerned learned court.
CGM Bongaigaon, my lord.
CJM Bongaigaon, and subject to the conditions that we shall cooperate with remaining investigation, not hamper or temporary dividends, shall not commit any illegal activities or offences. Violation will entail bail cancellation.
I'm obliged, my
Return-
lord.
Return case. Diary.
May it please your lordship, this is an fourth regular bail application, lordship, 29 days in jail custody, lordship, FIR will be fine on page 13, lordship. Only problem is that, lordship, the boy is 22 years and girl is 18 years. Of different religion, they fall in love, lordship, consequence of which, lordship, the parents, lordship, lost this FIR on the 9th. On the 10th, lordship, the boy arrested and produced before the CGM Bijni, lordship, forwarding report on page 16, lordship, kindly peruse the ground of arrest, lordship. They are in love relation, lordship. Already 29 days, lordship, because of that, lordship, different religion, even surname is same, lordship.
She is 18 years, that is major.
Yes, lordship. We have not received the case there, lordship.
Or you have not received.
Not received. 29 days already, lordship, girl is recovered, lordship, and she is major enough, lordship, to understand, lordship. She voluntarily looked, lordship, as para 4 in my petition, lordship, I have stated, lordship. Petitioner is 22 years.
Girl has been recovered.
Yes, lordship, that is stated in ground of arrest, lordship. Para 9, lordship, the kidnapped girl was recovered from the position and control of the accused, where she had been kept concealed in another house, lordship. Page 16. And moreover, lordship, police custody was not sought for, lordship, in the forwarding report, lordship.
Mr. Hard B. Chaudhary and PC Goswami. Invoking 483, the petitioner is seeking regular bail connection with Anbari PS case number 41 of 25 under so and so section. The FIR was lodged by one Kalpana Mandal on 9/12/2025 with the allegations that her 18-year-old daughter went missing on 8/12, and then thereafter she came to know that the accused person kidnapped her daughter on the previous day. So, as per the forwarding report, the girl has been recovered from the possession of the accused. The petitioner is stated to be aged 22 years. So the petitioner counsel submits that both of them are having a love affair, and due to being from different religions, the criminal case has been lodged upon him. Nevertheless, issue requisition for the case diary. However, in the interim, the accused is allowed to go on bail of rupees 30,000 with one surety. The satisfaction of the accused was arrested on the accused was arrested on 10/12/2025. Is allowed to go on bail of rupees 30,000 with one surety of the like amount.
Judicial Magistrate First Class Bijni Chidam.
GMFC business, and subject to the condition that he shall cooperate with remaining investigation and shall not cause any harm, harassment to the alleged victim girl. This is the matter on 29 or 30?
30-01.
30-01.
Highly obliged.
30-01.
Obliged.
25. 25. Yes. This is order.
25 and 19, my lord. This both are, my lord, of the same FIR, my lord.
24 and 19.
19, my lord. So
Okay.
25, my friend is appearing in this 25, my lord.
Thank you.
So, my lord, in
Decorative.
this case, my lord, Lordship has seen, my lord, in the charge sheet, my lord, that this accused, I'm for item number 19, my lord.
Yeah, we'll take it up together, or you make your submissions.
Yes,
then
my
we'll
lord.
Take it.
Yes,
up to- Just a minute.
So, my lord, in the FIR, my lord, 5 persons were there who are involved in the incident, my lord, in the offense, my lord.
Your petitioners are named.
My petitioners, my lord, Bappi Paul and my lord, Taposh Paul,
Yours is 19.
19, my lord.
Bappi and Topos.
Bappi and Taposh, my lord. So Bappi, my lord, already he in custody from last 172 days, my lord. And Taposh, my lord, 171 days, my lord. I have annexed the arrest memo, my lord. It shows the date of his arrest, my lord. So in the arrest memo, my lord, the ground which I have taken, my lord, the 36 has not been complied with, my lord. Secondly, my lord, if you go by the charge sheet, my lord, the only allegations against me from the CDR analysis, my lord, this Bappi Paul, applicant number 1, my lord, he is in contact with one Shantu Paul, my lord, Shantu Paul. So this is the reason for which, my lord, he was made an accused, my lord. And my lord, if lordship see, my lord, my lord, see page 42, my lord, ultimately the whole allegations is against Tuton Das, my lord. He is the mastermind, my lord.
Bappi led the police to places where the looted jewelry was found.
Yes, my
And
lord.
the cash was found.
That's-
There is some concern with regard to because they're considering their narrations. And if these are accepted, there may be some concern with regard to the testimony of witnesses, at least, because it has not started.
Yeah.
Mr. Borua.
My lord.
The prosecution evidence has not started.
Not started.
Not started. My charge is not yet framed, my lord.
Well, my lord,
Still in the, my lord, stage of appearance, my
They
lord.
are likely to threaten, I'm sure, because of their conduct, which is revealed by the
Yes, the
investigation.
allegation and, my lord, the materials collected during the, my lord, investigation, my lord, that is reflected in the charge sheet, are serious in nature.
I'll see it properly. I'll see.
my
go through
lord,
the case diary also.
already, my lord, this Tuton Das has been granted bail on the order of this honorable court, my lord.
Yes.
And Ayan Das also, my lord. I'm just placing the order of the
Okay, I'll see.
court below, my
I will
lord.
see. See that.
Yes, my lord, I'm just placing this article.
But there is a high possibility of threatening
But
because of their modus operandi. Like they committed, as per the investigation, they committed dacoity like an organized crime.
But my lord, if lordship
That
says,
is
my lord-
an apprehension.
Yes, my lord. But if we go, my lord, if you go by this, my lord, Tuton Das and 4 other accused has already been granted bail by this honorable court, my lord. On the same forwarding, my lord, Tuton Das has been arrested, my lord. If lordship sees the, my lord, the forwarding report at page 21, my lord,
This is for.
this is the order, pursuant to order of the honorable, this honorable high court, my lord. This
No, this is
Tuton Das has been granted bail, my lord.
CJM Sribhumi.
Yes, my lord. Lordship may kindly. And Ayan has been granted bail on that order, my lord. After submitting of the charge sheet, my lord, Ayan Das has been granted bail, my lord. He was released on bail, my lord, by that order itself, my lord.
I'll have a look. I'll see it.
And I have been informed another 2 more accused person has been granted bail by that. If your lordship
Can I
come
keep it for some time?
yes, my lord, my lord. My lord may kindly come to page 21, my lord.
I'll hear the prosecution later, after he completes, after 25 submission is complete. Item
Yes,
25.
my
Then
lord.
I'll
So my humble submission, my lord.
together I'll hear you.
Yes, my lord, yes.
But my lord, page 21 is a forwarding report, my lord. Page 21, forwarding report starts from page 19, my lord. Lordship may kindly come to page 21, my lord. So Tuton has been forwarded along with these 2 applicants, my lord. Bappi Paul, Saurabh Paul, Tuton Das, and Taposh Paul. So I am for Bappi Paul and Taposh Paul, your lordship. Lordship, I have indicated my lord Tuton Das has been granted bail, my lord. He was granted bail on, my lord, 14/10/2025, my lord. And this is the order he was being released by the court, my lord.
Anyway.
Apart from this, my lord, I will take your lordship to page, my lord, 15, my lord. There is an arrest memo, my lord. Lordship has seen, my lord, the mandatory provision of 36, my lord, has not been complied with, my lord. at least, my lord, attested by at least one witness who would be the member of the family or a respectable member of the locality where the arrest is made, my lord.
Nothing.
If lordship sees, my lord, both the arrest memo, my lord.
In such a serious case, they have not taken any signature of witnesses.
Yes, my lord.
No, my lord, in this respect, my lord, I beg to submit, my lord, section 36, my lord.
We'll hear you later.
No, my lord.
To get after let him submit 25 here. I've made my notes. Right. Then if necessary, you can supplement also.
Yes,
right?
ma'am.
I'll wait for it. For you. Yeah, no, wait, huh? 19. 19 number.
That regard, my lord.
After something.
In that regard, my lord, I want to place DK Basu lordship is aware DK Basu judgment, my lord. 1997 1 SSC, my lord. Just paragraph, my lord, this 35.
Unlike Zihan Kumar, it is, does it entitle you to bail automatically? Unlike Zihan Kumar,
My lord, yes.
if there is no compliance,
Yes, ma'am.
does it?
My lord, that in that respect, my lord, I beg to, my lord, point out section 36, my lord, of the BNSS, my lord.
In other words, that is an informative, but is it a
36, my lord, yes.
is it a fatal informative? That's my question.
Yes, my lord. Now may I read, my lord, section 36, my lord. Procedure of arrest and duties of officer making arrest, my lord. Every police officer, while making an arrest, shall bear an accurate, visible, and clear identification of his name, which should be facilitate easy identification. That has been done, my lord. Prepare a memorandum of arrest which shall be attested by at least one witness who is a member of the family of the person arrested or a respectable member of the locality where arrest is made, my lord. Now, my lord, countersigned by the person arrested. Now, my lord, 36C, my lord, that I am back to refer to, my lord. Inform the person arrested, this is important, my lord, unless the memorandum is attested by a member of his family that he has a right to have a relative or a friend or any other person named by him to be informed of his arrest, my lord. It means, my lord, every police officer while making an arrest shall inform the person. My lord, if we do not, my lord, read, unless the memorandum attested by a member of his family, if we do not read this, my lord, then inform the person that he has a right to have a relative or a friend or any other person named by him to be informed by his arrest, my lord. That means, my lord, suppose a person has been arrested, my lord, and there is no relative, my lord, at the time of his arrest, my lord. Or even, my lord, some, as per section 36(1), my lord, the respectable member of the locality was not present, my lord.
Nobody is
Then,
there.
my lord, yes, then, my lord, police officer may say that he has a right to have a relative or a friend or any other person named by him to be informed of his arrest, my lord. That means, my lord, even, my lord, no person has been
May not be fatal.
attested,
If
that
it is-
may not
if
be,
the
my lord,
second
prejudice
clause-
to him, my
If
lord.
the second clause is complied.
Yes, my lord. And what is, my lord, the arrest memo, my lord? Arrest memo, my lord, only the intimation that your movement has been restricted, my
Yeah.
lord.
Notice is now
Now, thereafter, my lord,
information to the accused is now taken over by 47.
yes, my lord.
47.
Then 47, 48 will come, my lord.
47.
Initially, arrest, my lord, then 47, 48 will come.
Anyway, we'll see. Yeah.
And if you go, what my learned friend has submitted, my lord, if you go by judgment of my lord, DK Basu, my lord, is something different,
No,
my lord.
DK Basu is clear, my lord. That
Yes.
has to be attested, my lord. There has to be one attested witness, my lord, in the
That is the
memo of
question.
arrest.
Suppose
is
it
the
is
question.
not attested,
Yes,
it
my lord.
automatically entitle the person to bail.
Yes,
Like Dihan Kumar, if it is not there, Dihan Kumar does not talk about substantial compliance.
my lord.
Right. So what is the position here?
The
I'm trying to
position, my lord,
refresh.
that I refer to, my lord,
Probably it's
36, 36C,
Not
my
clear,
lord.
probably.
36C, my lord.
36. According to you, if that is complied, the third clause is complied, then
Comply,
it won't be
there
fatal.
is no prejudice, my lord.
It won't be fatal.
Even after that, my lord,
We have to see
47,
the 47 notice. 47, 48 notice is here. in this
47,
case.
48 notice, my lord, there I have to go through, my lord.
Anyway, you see, so that is,
25 to
that takes precedence over 36.
Yes.
Actually, the arrest procedure, the arrest memo is about the arrest procedure.
Yes, my lord.
One part of arrest procedure.
Yes, my lord. They all are independent, my lord.
If he and his relative both have been properly informed, then automatically it may not be entitled to be granted bail. It should be followed, no doubt. Yeah, then it may not be a fatal infirmity, perhaps. Anyway, we'll see. Before we conclude the hearing in the next round,
My
like
lord.
25 is heard, you kindly check that 47 notices.
Yes, my lord.
These are recent arrests, so if they must have followed.
Quoted, my lord,
They
I
must have
may,
followed.
can I have the scan copy to do it? 19 to put it, no?
But even this informality should not be there.
Yes.
In this kind of cases, they should
Yeah.
take someone's signature.
My lord.
Let it be a stranger from the locality, doesn't matter, but signature,
My,
should be
yes,
there.
my signature.
That should be taken.
So I thought my submission would be what my land plan submission, my lord. It's a mandatory provision, my lord, statutory
Because
provision.
we have
my
to
lord.
balance
Yes.
both things, you know.
Yes.
The way they, the allegations, you know, the way they committed the dacoity according to the investigation. Extremely likely that they will be threatened not to give any evidence against them. Anyway, we'll see that.
My lord. So, my lords, thirdly, my lord, this, since co-accused has been granted bail that I have submitted, my lord,
Yes.
since, my lord,
That's
because
okay.
this is one of the ground, my lord, for which, my lord, we are praying that
That's
the
okay.
petitioner may be,
I've
applicant may
written
be
down
released
also.
on bail, my lord.
Okay, let's move on.
And, my lord, the length of detention, my lord, because
Okay, I will
already,
keep
my
it.
lord, 172 days, my lord, in custody.
That is on the higher side, no doubt.
Yes, my lord, on higher side, my lord. And my lord, I am also submitting, my lord, he has the right to defend this case, my lord, because if you go by the, my lord, allegations, my lord, if lordship sees the allegations, my lord, it is, my lord, 310 dacoity, 311 115, my lord. But if you go by the charge sheet, my lord, it is only on the basis of the CDR analysis, my lord, we have brought into the picture, my lord.
The CDI analysis is nowadays a very important part of investigation.
Yes, my lord,
This
but-
has to be seen. They
Yes.
prepare a spike model, you know, this, where, you know, how many calls to what around this time.
Yes.
And then the contents have to be seen. Then you can go
Yes,
inside and
but-
see the actual conversation.
The-
Actually, Mr. Borua, it should be, not only the calls.
Yes,
A
my lord,
person,
that I am submitting.
and another acquaintance can also call.
Yes,
Suppose
my
a
lord.
person is committing crime,
My
you know,
lord.
we have to see everything fairly.
No.
Suppose a person is committing a grave crime, suppose. At that point, he may receive a innocuous call also from
Yes, yes.
someone.
No, it is not
who
that,
knows
my
him.
lord. It is not that, my lord. On that day, my lord,
Yeah,
there may
but
be
the
several
contents
calls, my
also
lord.
should be entered in.
Only, my lord, whether, my lord, there are any, my lord, telephonic in conversation
Yes,
between
yes.
the, my lord, the
It
accused
raises
person or
suspicion.
suspected accused person.
It raises suspicion.
Yes,
But
my lord.
if you see the contents, then you can come to know what they talked about.
Yes, my lord. Because, my lord, police has to, my lord, go step by step, my lord.
Step, yes, step.
So, my lord,
Both has
according-
to be balanced. Everything has to be balanced.
So-
Nothing is absolute.
So, my lord, so my submission would be the charge, my lord, we are C10, 311 and 115, voluntary closing hut. These sections will not be attracted to the petitioner.
Okay, I've written it
Yes.
down. Okay, let us move on because others will,
Mistake.
lot of matters,
Yes,
others
my
will
lord.
get late.
Yes, ma'am. 25.
If necessary, you can reply after 25.
Yes,
You can,
yes, yes.
you can supplement. 25?
25, Lordship.
So you're submitting now only. Okay.
Lordship. Only thing is that, Lordship, page number 56 of my
25.
25. Lordship.
Have a look.
Hold on. 25. sorry.
Yes, make your submission.
Page number 56, Your Lordship. This is the charge sheet, Your Lordship.
Mhm.
Page number 56, third para, Lordship. This is the allegation against me, Your Lordship, and I am confessed to that. Bappi also confessed that stolen money and ornaments were kept at the house residence of Saurabh Pal. Saurabh Pal is the petitioner in this petition, Your Lordship, who is his relative. Saurabh further helped by taking Santosh Zamir and so residence answered the incident. Following this disclosure, the police proceeded to the house of Saurabh Pal at Dolu. While during the interrogation, Saurabh confessed that both he and Tuton were standing outside the victim's house on the night of occurrence. After the commission of crime, Saurabh transported the accused Santosh so-and-so in his auto rickshaw to facilitate their escape towards Dolu, Your Lordship. Now, Lordship, may I kindly see annexure to page number 14, Your Lordship. Same section 36. Mandates of section 38 has not been complied with, Your Lordship, so far as Saurabh Pal is concerned. And then your lordship, annexure 4, this is the section 47 notice, your lordship, page number 17.
63.
Page number 17, annexure 4. This is the notice under section 47 of UNSS. FIR was registered on 19/7/2025.
Grounds of arrest are in sufficient detail. Grounds of arrest with regard to him. The other one I have not seen.
Now, lordship, one thing, page number 19, last.
Bilingual also it's.
Page number 19. Date 15/7/2025.
Mhm.
3 dates, lordship.
When was he arrested?
On 19/7/2025.
OP
Arrest
testing.
memo at page number, your lordship,
OP testing.
14.
Arrested person, Saurabh Paul.
Page number 14 is the arrest memo.
Mhm.
Notice under section 47 is 3 dates on 15/7/2025, your lordship.
But his signature, they must have made a silly mistake.
And then, your lordship,
I will go to the narration of the charge sheet. Yes.
and page number 62, your lordship.
62.
Sixty-one is the type copy, your lordship. The order that I have annexed, your lordship. Accused person so and so already granted bail to Tutan Das, who is the mastermind, has been granted bail by this honorable court. And second last of the bottom from bottom, Orandash has already been granted bail. And as per instruction, 2 others has already been granted bail by the Chief Judicial Magistrate, Sevu Minish. His master. And he is behind the bar since for 173 days as on today.
Yes, any submission you want to make?
The same submission, my lord, and secondly, my lord, that order, lordship may kindly peruse, my lord.
Which order?
My lord, order dated, my lord, 27/2025 of the, my lord, trial court, my lord. Where David said, my lord, produce after arrest, my lord. Scan copy to দিব, sir. Scan copy to ওলাই দিয়কচোন, প্ৰথম order to flag কৰি দিছো। It is not pinned, my lord, so.
No problem. That's what I'm saying. Yes.
Appearance.
Next page, my lord, next page, please.
Now I've seen, this is also mentioned in the charge sheet.
So this is a, my lord, since it is a judicial order, my lord, it has been mentioned, my lord, clearly that 47/48 notice has served to, my lord, all this accused person, my lord. Well, at this stage, my lord, only whether the prima facie, my lord, whether the offence they have committed, my lord, and what are the materials in the case diary, my lord. Since the my lord, offence committed is my lord, my lord, serious in nature, my lord. So, my lord, considering the gravity and nature of the offence, my lord, at this stage, my lord, I oppose this bail application.
Third, also, almost very common order of it. All of the petitioners Bapi Paul and Tapas Paul invoking 483 BNSs are seeking regular bail in connection with the Ramakrishna Nagar PS case number 56 of 2025. They were arrested on 19/7/25 and 27/7 respectively in connection with this case. The allegation in the FIR was about dacoity in the house of the informant, during which they also caused assault and harm. Stuff. For investigation resulted in a charge, and it is submitted that in the meantime charge has also been framed.
No.
Charges not in. And the case is poised for the case is at the stage of appearance and poised for framing of charges. Stuff. The learned petitioner counsel draws attention to the length of detention and also submits that the memo of arrest under section 36 of BNSS does not bear signature of any witnesses. In this context, the learned additional PP brought my attention to the provisions of section 36 BNSS and submits that in this case, the grounds have been conveyed properly to the accused as well as to his relative in compliance with notices under section, in compliance with section 44 and 48 BNSS. Full stop. I have gone through the detailed narration in the charge sheet under the heading brief facts of the case. Full stop. If these materials are accepted on face value, it would show the involvement of the accused persons along with others in committing the alleged offense of dacoity/robbery, during which the victims were also assaulted and tied up. Now the accused persons are also found to be involved in other criminal cases, the details of which have been given. Full stop. From the charge sheet, it is also revealed that the alleged offences were also committed in connection with some other habitual offenders who, after the incident, were hiding. Some of whom, after the incident, were hiding in the Assam-Nagaland, in the area of Assam-Nagaland border. I have given my consideration to the matter, including the aspect of detention. However, considering the manner of commission of the alleged offences and the fact that the examination of witnesses, including the victims, has not started, there might be some concerns regarding their safety and proper deposition at this stage. Therefore, I am of the considered view that it would be prudent to refuse bail at this stage in the larger interest of the matter. Full stop. Accordingly, the bail petition stands rejected at this stage. Return back scan copy. Scan copy has been received. You can take back this original copy. You want?
Obligation.
Please take it. Six.
Regular bail second time, my lord. Your lordship's order is by the page 26, earlier on. 24. The petitioner, when I married one lady who belongs to other religion, my lord. After 14 years, case was filed, having 3 children. I am only on that, my charge should also file, my lord.
Yeah, charge sheet file.
Charge sheet file. And your lordship will charge sheet section 534. And another co-accused are given away by your lordship now. Hello.
Any submission? Case diary, this
No,
charge sheet-
10 copy was called for, my lord. My lord,
It is calm, I think.
it was on 12/12, it was earlier rejected, my lord.
Yes, yes.
Yes.
Then it is a charge-sheeted case, my lord.
1 month, my lord. Further custody, I am on that, my lord. Merit also, your lordship. That is a big co-accused, every one. Only, my lord, after 14 years, as per FIR, my lord, your lordship.
Oh, I say, rightly or wrongly, whatever, I pass this order that trial has started now, no?
No,
Trial has
yet,
not started, my lord.
not charged yet.
Victim has not yet been examined. Otherwise
That's
I'll
why,
be
my lord.
contradicting myself.
Yeah.
The victim has not yet been examined. And let the victim be examined then,
Yes, my lord, that.
Only, my lord, charge not been framed, it will take
Charge-
time, my lord.
That's the thing. Otherwise, rightly
Your
or
lordship may
wrongly.
modify your lordship's order, my lord. It is before your lordship, my lord. Charge not framed, my lord, how many days and how many months it may take, my lord. Who is there? And already further custodial interrogation also, my lord.
That is not necessary. No.
Hmm?
Yet to be committed.
Yeah. Not yet committed also, my lord.
Not committed also.
Not yet committed. And husband and wife, my lord, after 14 years, my lord, case was filed. And if your lordship, I think, my lord, nobody will be prejudiced, my lord, at least, my lord. If you cooperate.
Senior counsel, RJ Bora. Our order was sent. This is subsequent bail petition, as earlier bail petition was rejected on 12/12/2025 in BA 3678 of 2025. The case is already charge sheeted, as also reflected in the earlier order, and reached the stage of trial. Was observed in the earlier order that considering the nature of allegations, alleged conduct of the petitioner, and the fact that victim has not yet been examined, the bail petition was refused at that stage. This is submitted by the learned senior counsel that in the meantime, approximately 1 month has elapsed, but the case is yet to be committed. While the petitioner languishes in jail. So it is submitted and prayed that
3 months.
perhaps press view may be taken upon his continued detention. Scan record has been received. I've given my consideration to the case. Yeah, learned prosecution does not dispute the stage of the case at present. Considering the fact that the commencement of trial and examination of important witnesses, including the victim, might take some time. Perhaps the subsequent bail petition can be accepted by imposing suitable conditions. Accordingly, he is allowed to go on bail of 40,000 with one surety of like amount. Conditions of he shall be available for trial. He shall not hamper or tamper with evidence. He shall not in any manner intimidate, harass, or harm the alleged victim woman. In case of violation of any bail conditions, the bail would be liable to be cancelled.
CGM मंगेगा मैं.
CGM disposed of.
Obliged to us.
May I please, Lord?
This is a regular bail application, Lordship. As on today, 35 days in custody, Lordship, and 3 days in police custody, Lordship, thoroughly interrogated by the police, Lordship, during custody. And Lordship, it's a case of violation of section 36, Lordship. Lordship may kindly come to page 30, Lordship, 30. 26, Lordship, sorry. Last para, Lordship, ground of arrest communicated to the arrested accused person by issuing notice under section 47 BNSS. The arrest memo and inspection memo have been duly served to the accused person, informed and his guardian family members by issuing notice under section 48 BNSS, medically examined by him by the GOP doctor. But 36 has been not complied. And so far, it's section 36, Lordship, coordinate bench has passed.
What is the allegation against her?
Allegation only some FIR page 15, Lordship. Some video has been viral through his mobile, Lordship, and 20,000 has been received from the informant for vacating a soap, Lordship. This coordinate bench has discussed about the section 36, Lordship, elaborately discussed, and after discussed, Lordship, granted bail to the in NDPS cases, Lordship. Commercial quantity involved for it, Lordship.
It has been rightly said, you know, that it is a memorandum of arrest is a document which document of proof regarding the arrest.
Arrest,
That the
that
person
is-
was arrested.
Yes, my lord. When the arrest moment is served, my lord. When
Eh,
the person is brought to the
Whether
police
it was
station,
arrested or not. You know.
or my lord,
Main
that
thing
has been.
grounds have to be conveyed.
Yes, my lord. Now, my lord, my submission will be same, my lord, as per section 36C, my lord. Now, my lord, in this
She
case,
can
my
be
lord, we have-
granted bail on other grounds. That's the thing.
What order I have been.
no, at the same time, lord, we will also have to see the, my lord, gravity of the offense, my lord. Because under what section, my lord, that lady has been booked.
Already NDPS case has granted bail, Lordship, commercial quantity where it involved. This is a case of BNSS,
As I
Lordship.
said, you know, I
And
think,
only some video
no,
viral
No,
and
in this-
20,000 have been
no, in
received.
this
This is
case, my
allegation.
then the court will seek a judgment like Bihan Kumar, where of the Honorable Supreme Court,
Yes.
which says that in case of violation of 36,
36,
if there is no signature of witness or person, automatically entitled to bail.
In that respect,
There is
my
no
lord,
judgment. like
DK
that.
Basu is clear, my
We'll
lord.
wait for a judgment like that. But so far, there is no judgment. Thing is that it is a proof of arrest. It is a
Yes.
proof of arrest. And subsequently, if the grounds of arrest have been conveyed properly, 47, 48 is complied,
Complied.
then some infirmity in 36 may not be fatal.
My lords, my lords, absolutely correct.
We can all be wrong.
But now, my lord, in this case, my lord.
Because as I said, these are all evolving laws. It will stand correctly.
And this case, Lordship, he is a lady, Lordship. He is a
Okay.
As I
president.
said, she can be, her bail can be considered on other grounds also.
Yes.
Today, we have not received the case diary, my
Oh, you
lord.
have
I always
received the
paid
case
for a
diary.
time short date, my lord, to produce the case diary.
I thought the case diary had come.
He is a president of an NGO, Lordship. Some
Then you'll have to wait for some time, because tomorrow it will not be practicable, I think. If you can get it tomorrow, okay, I'll.
On 19, my lord, immediately after
Silchar,
reopening.
Silchar will not be
Immediately
possible.
after reopening.
19.
20, Lordship.
His diary is not yet received. So, the Mr. Bogohai Learned Counsel for the petitioner submits that there is infirmity in compliance with section 36 BNS. The case diary not received, issue fresh requisition, fix on 20. Should I keep this?
Always.
May it please your lordship. This is the 483 application, my lord. Type copy of the FIR is page number 12%.
To 28 also, we have not received the case diary, my lord. I always paid for some time, my
My
lord, to
prisoner
produce the case.
transferred it for 27 days, lordship. A old lady, my lord, 56 years old, lordship. And may I,
Just a minute. What is the allegation?
my lord, suspecting that petitioner has caused the death of the petitioner's husband, lordship. It was lost by a villager, lordship.
They were quarreling and perhaps
Yes.
something happened. Then.
27 days judicial custody, lordship, and 56 years old, my lord.
Inside case, actually. Kindly wait for the case diary. You, case diary is
Case
not.
of
yet received.
103, my lord. this is.
Yes, that is one. Kindly wait for the case diary. Call for the Panigaon. Where is Panigaon?
Lakhimpur, lordship.
Lakhimpur.
Panigaon.
Tomorrow in Lobis. The accused was arrested on 13/12/2025. Call for the case diary of Panigaon PS case now, 88 of 20. List on
22, my lord, 22-1.
Give him a little early, since,
Then 21-1, my lord,
okay,
21.
one day, not make a difference.
But in this case, our learned senior counsel, Mr. J. Kumar will appear. Can it be a two, my lord?
Obliged.
Seventeen. Iriana is one population.
30.
7-0. Scan copy has been received,
This can be not received, my lord. I have verified from the record, my lord.
not received.
Not received, my lord. At 2 p.m., my lord. Then.
Lordship, I beg to mention item 35. My senior counsel is taken leave.
35, but there is scanned record. Scan copy there, okay, 30. No problem, after vacation, after. Leave the matter on, and they take the date. It's on 22, 22-1 to 20,
Order may continue.
interim order shall come, 22-1.
Being item 17. Instruction pending as.
Shashit sab university.
90 days in custody, Lordship, that may be considered.
It's 13-10, right? Third, so and so. The accused, this is the first bail application, right? That's right. The accused was arrested on 13-10-2025 in connection with Kamalpur PS case number 123 of 2025 under influence of section. Based on a FIR lodged by the victim herself on 3-10-2020. He was arrested on 13-10 or 3-10. You have written 13-10.
13-10.
10 days after the lodging of the FIR.
Yes, forwarding is also 13-10.
The gist of the allegation is that the accused person, while coming to buy some medicine from the informant's Ayurvedic pharmacy, suddenly attacked her and tried to attack her, tried to attack and assault her. Prosecution submits that in the meantime, investigation has been completed, resulting in a charge sheet against the petition. Considering that aspect of the matter and length of detention, he is allowed to go on bail of ₹40,000 with one security of the like in it, with the satisfaction of the concerned learned court, which is the court, learned court. Kamalpur would be Amingaon.
Yes, sir.
Amingaon, CJM Amingaon. Kamru Amingaon, and subject to the condition that number one, he shall be available for trial from convinces, hamper or temper. He shall not in any manner intimidate or harass the informant/victim or other witnesses. Next. This person.
And we can see.
Yes, sir.
One of the previous bail application, my lord, the Wet Commission of Suicide. At the outset, my lord, I have been engaged, I am to be here, my lord. Unfortunately, the deceased is related to a very, he is also a friend of ours, my lord, a lawyer friend. So a lot of my friends are opposing, my lord. Yeah, my lord,
My lord, we are referring for the informant. my lord.
Informant.
My lord, the affair occurs at page 15, my lord.
Okay.
Page 15, my lord. 15 second paragraph would be very pertinent, my lord. May I read, my lord? It is worth mentioning that the suicide note, there is a suicide note, my lord. And this should be, in my understanding as a student of law, my lord, would be a 161 statement, because there was a prior affair, both have been merged together, my lord. It is worth mentioning that the suicide note written by my daughter before committing suicide was seized by you from the place of occurrence, wherein my daughter fully made accusation against one boy, namely Jitu Datta, for her suicide. On the basis of the said suicide yesterday, that is on 15/12/25, so and so, I made inquiry and it came to know from the last few days that Jitu Das, father of Vipul Das, and mother so and so, so and so, so and so, had been physically and mentally torturing my daughter Nabanita Sharma, especially outside and inside the campus of National Law Tribunal, Guwahati bench. Bhavan Pan Bajar, regarding the same, the staff of NCLT and tea shopkeeper named so and so, so and so, so and so are aware. Moreover, on the last on 12/12/25, i.e. on the date of incident, in the evening, the said Jitu Datta is, in absence of other members of our family, entered into our house and also assaulted Nabanita. Moreover, as informed by my friends, my younger son, it goes on and on, my lord. There was some physical and mental torture on her, my lord. Prior to this, there was another affair, my lord. That also we have annexed, my lord, that occurs here. Page 23, my lord. Page 23, my lord. Lotte may have found, my lord.
Yes.
The affair which I read out is dated 16/12, my lord. 16/12, my lord. That occurs at page 15, my lord. At the first affair, that is at page 23, my lord.
Dated 13/12, right?
13/12, my lord, prior hand. This would be the affair, my lord, in fact. With due respect, I beg to inform you that today on so and so, my daughter, namely so and so, committed suicide at her residence inside her room by hanging herself in a ceiling fan and closing the door. At around 4:10 p.m., after breaking the door, I noticed her in a hanging position. It is requested your good self for taking necessary steps regarding the aforesaid affair. She is 28 years of age, my lord. Very unfortunate happening. That should not have happened. This is dated 13/12, my lord. And now both the affairs have been merged, my lord. This is by an order of a learned magistrate, my lord. That occurs at, I'll be very quick, my lord. Page 34. Accordingly, pair of IO is allowed. Let the Jalukbari PS case number so and so be amalgamated with Jalukbari PS UD case number. That affair dated 13/12, my lord. Now merged, my lord. The investigation will proceed in the UD case, my lord. This is the factual matrix, my lord. Now, our part of the story, my lord, that occurs at, my lord, with whole respect, my lord, kindly have a look, my lord, page 6, para 9. Page 6, para 9. We have stated everything, my lord. There's a long-standing love affair. Then, because of caste differences, marriage was not solemnized or solemnized, my lord, could not be solemnized possibly. This is our part of the story.
Para 6.
Page 6, para 9, my lord. May I, my lord? I'm reading it, my lord. That the petitioner begged to state that the petitioner came into contact with the informant's daughter and developed a friendly relationship with her in the year 2015. And subsequently in the year 2016, they entered into a romantic relationship. After the petitioner joined the Amity University, Kolkata, for his higher studies, as the informant's daughter was also a student of the said university. Thereafter, in the year 2019, after completion of his studies, as well as because of lockdown arising out of COVID pandemic, they returned back to Guwahati and they continued their relationship, which was known to members of both the families. So some lies somewhere, my lord, that they were in a relationship, both the families know.
And they even travel to different places as such Shillong, Darjeeling, Orna, goes on and on, my lord. Thereafter, para 10, my lord. And, my lord, another line in that paragraph, my lord. Furthermore, the parents of both the petitioners and the deceased were well aware about their love relationship and also having good relationship between both the families. Anyway, my lord, para 10. Now it has gone sore, my lord. The petitioner beg to state that both relationship for the past 10 years and without any serious dispute or differences, except some minor trivial issues which do crop up between couples who are in love relationship. But since past few months, the victim's behavior towards the present petitioner gradually started to change. And whenever the petitioner tried to know the reason for her such behavior, she never gave any proper reply. Thereafter, 11, my lord, leaving aside some lines from the top. Even after knowing that the daughter and the present petitioner were in a relationship for around 10 years, they were not willing to solemnize their daughter's marriage with the present petitioner as he belongs from a different caste, and so that the reason goes on and on, my lord. Thereafter, leaving aside some lines, upon knowing that the said boy, that the said boy was one with another boy, marriage was arranged, my lord, one with whom the informant side were trying to solemnize their daughter's marriage, the petitioner disclosed that the said boy about their relationship and tried to persuade him not to interfere in the same, but instead of acceding to the request of the petitioner, the said boy initially entered into a verbal argument with the petitioner, and subsequently same resulted in a physical altercation. That, my lord, on the date of occurrence, the girl was beaten up. That allegation there in the first information report, my lord, is absolutely contrary to truth. In fact, this incident occurred, and had there been a boy beating up a girl, there would have been injuries. There cannot be. That may be on record, my lord. No injuries were there on her, my lord. That harassment is missing. Again, page 9, para 13, my lord. Leaving aside 3-4 lines from the top, my lord. The victim was pressurized by her parents to avoid the petitioner, since the petitioner belongs to a different caste, forcefully fixed her marriage with another boy, as the result of which the victim might have taken drastic step for ending her life. Furthermore, it is pertinent, goes on and on, my lord. Now, my lord, whatever be the case, my lord, very unfortunate happening. But, my lord, being in love and thereafter going apart, my lord, there may be some tips, my lord. But do they, my lord, with all respect, my lord, tantamount to, my lord, with all respect, my lord, abatement, my lord, which is there in, my lord, with all respect, my lord, section 45, my lord, earlier 107 IPC, my lord. I am not to read 45 because 45, my lord, 3 things are apparent, my lord. Even if I scold her, say, assuming the allegation in the FIR is true, 45, my lord, with all respect, my lord, there has to be instigation that commits suicide, definitely missing, engages with one or more person or persons in conspiracy for doing that, 45B, missing, my lord, C, intentionally aids that I give the rope to her. These are absolutely missing, my lord. But unfortunately, my lord, already I was engaged, that's why I have appeared. I also would not have appeared because the girl, unfortunate happening, my lord, she is a relative of a very I'm a dear friend of ours, my lord. He also belongs to my community, my lord. This is the case, my lord. But anyway, I was engaged. I am doing my part of the job, my lord. My lord, a boy in love with a girl, definitely he will never want that she would vanish from Mother Earth, my lord. That will never happen, my lord. And in any case, whatever be the allegation, it cannot be abatement of a thing, my lord. Abatement would be missing, my lord. This is my case, and I'm praying for interim, my lord.
And they have not. Case diary, we have to call.
Case diary will reveal everything, my lord, because there is a suicide note out there, and suicide note has already been seized. Everything will come clear, my lord, crystal clear what the note says, my lord. How it is his defense case. Without saying the case diary, my lord, not
mental and physical harassment, my lord. Mental and physical harassment, assuming it is true.
The suicide note will speak volumes.
Let it be on 19th. Just call for the case diary.
Can there be interim, my lord?
No interim.
What about?
No, they will oppose, my lord. Definitely they will oppose, my lord.
That's why we are here, sir.
These are unfortunate things.
But the effort does not make out a case,
A
my
brilliant
lord.
girl's career has been demolished, my lord.
Oh, that is emotional part of being, man. Let us go by not the legality of law, my lord, not the philosophy of law. Philosophy of law is to be left to the legislature, my lord.
Let the diary come, everything, philosophy and geography will come.
They
They
are in relationship for 10 years, my lord. And no, those things are hidden from the affair, my lord.
Everything will come in the case diary and we will argue.
Call for the case diary of Jalukbari PS case number 501 of 25 under so and so. With regard to the alleged
Injury report
suicidal
different
death of the
position, nine.
woman's daughter, one information was lost to the police station whereby a UD case was registered and subsequently on 17/12/2025, formal FIR, 16/12/2025, a formal FIR was lodged. And subsequently, both the cases were amalgamated. The informant alleges harassment from the side of the petitioner, ultimately resulting in suicide of his daughter. Mr. Mahajan submits that they were in a relationship for a long time, and due to some caste differences, there was opposition to marriage, and ultimately this tragedy happened. Mr. Jait Kamal and Senior Counsel appears on behalf of the informant, DP Goswami. For the case diary, fix on 19. It would be on 19.
My lord, can it be little bit postponed, my lord? Can it be on 22nd? We may not be there, my lord. 22nd, my lord.
Let him have his own convenience. 22, I'll.
No, not my convenience. I just.
No,
gave-
no,
I gave a.
he'll be out of station.
Since interim is not there, so I gave.
No,
19.
he's saying that
No problem.
he will be out of station, so on
22nd.
22nd.
Highly ordered.
No issues. The
Obliged,
relationship going wrong is definitely painful, but I have realized from my, not general life experience, that we must have the ability to accept no in everything.
Right.
We should have that strengthens you.
Right,
Strengthens you.
that's
Fail-
very
it
correct.
Can fail, a relationship can fail. Long relationship can also fail, but if we have the ability to accept no, then it strengthens. Suicide is such a big tragedy.
Yes, very
One should think of one's parents at least one's mother, who had spent sleepless nights to bring up a child.
Absolutely, to bring up a child, my lord. And
Life
suddenly
life is more important than relationships.
Absolutely.
My lord.
Mark-
Obligement.
For young people, it's an impulsive decision.
Mine.
60 feet away.
But in this case, my lord, before to start with it, my lord, with the case materials, my lord, I'd like to point out, my lord, this is a 439 petition earlier section, my lord. Now it is, my lord, 483, my lord. I was arrested and put behind a bus. Then I filed a BA 3716, which your lordship is dealing with it. And in that case, I was granted interim bail, my lord, white order dated 8/1/2006, my lord. On merit itself, interim bail was granted prima facie by this honorable court, my lord. And at para 5, the main part is there in the order.
No issues. Now what, Darius come?
Yes, Darius come, my lord.
So my, I'm already on bail, my lord. And the thing is that, my lord, that 2 conditions were given, which I fully complied with it. Whenever I was called, I went there, and I have never intimidated any of the witnesses. And there is no adverse remark as of now has been brought on record, my lord. So again, putting me behind the bars will not serve any purpose, my lord.
This was also out of a relationship. It went wrong.
Absolutely. These are all that last and all, because the girl was taking the part, my lord. She is a major age at about 25 years, my lord. Because of service and all these things.
Case diary revealed, my lord, as per her 183 statement, my lord. She has implicated that, my lord, to the extent that, my lord, she was also employee of BR, my lord.
Same.
NRL, my lord. And the, my lord, accused person, he was the deputy general manager. Then, my lord, there, my lord, friendship started, then it turned into a love, my lord. Then, my lord, accused person also took her to a temple. He put vermilion on her head, my lord, saying that, my lord, he would marry her, my lord. But later on, she came to know that, my lord, the accused was already married, my lord, having child, my lord. Then,
So she came to my house, my lord. It is a ridiculous story if a married person will bring before the girlfriend before a wife, my lord. She has stated that way in the FIR. So I pray that I'll cooperate with the investigation, my lord. Whenever I'll call, I'll not misuse my liberty, my lord. And today, as on date, my lord, 60 days from the date of this has passed, my lord. So kindly maybe made absolute, my lord.
The petitioner was granted interim bail on 19/11/2020. So, in the meantime, can I have a look at the,
Yeah, my lord.
in the meantime, the case diary
Yes.
call for has been received. Mr. Boro and Learned additional PP submits that the statement of the alleged victim was recorded before Learned GMS, in which she has stated about a relationship with the accused petitioner, and subsequently coming to know that he was already married with a child.
And during, my lord, during their love relationship, my lord, they also entered in physical
Yes.
relation, my lord.
The lady booked the room herself, my lord. That has come on records, my lord. That's why interim bail was granted under 439, my lord. Which are 439? 483. 483.
Oh,
482 and this.
তোমরা খেলি মিলি হয়েছে গোটেইবিলাক এতিয়াও খেলি মেলি হৈ আছে বিদেশবিলাক মূৰত সোমাই আছে IPC বিলাক মূৰত সোমাই আছে
And he got married also in the.
Yes, my lord. That is what she has stated, my lord. Because she wants to be put into her service, confirmed service, my lord. That's why the whole case has been filed, my lord. Because her service was not confirmed. He thought I am a man in position, so I'll be able to give her this job, my lord. That was the condition in the FIR, and more or less probably 164 will be all the same, my lord. So it was more of a consensual
This
nature
is the
of
statements of the alleged victim girl available in the case diary. Seen the progress of investigation. Stuff. There are some implicating materials revealed by the investigation. Nevertheless, it appears that the whole matter arose out of the supposedly illicit relationship between the informant and the accused. In the entire facts and circumstances, it may not be necessary to cancel the interim bail. Accordingly, the interim bail is hereby made absolute, subject to the condition that he shall cooperate with the remaining investigations, shall not hamper or tamper with evidence. He shall not in any manner
I'll cooperate with the
intimidate, harass, or harm the informant slash victim. Violation of the bail conditions will make the bail liable to be cancelled.
Madam, my submission may be recorded, madam, that in the 183 statement she has implicated.
Yes, yes. The learned additional PP submits that in her statement before magistrate, she has implicated. She has implicated the petitioner.
Much obliged.
She was he got married in a temple. You know, says, and
Yes,
then
he took her, my lord, and he took her to a temple, my lord, and put Bharmila.
and then he went to his place in Ganeshguri, where one little girl came running into his lap,
Yes, my lord.
calling Papa.
That is the latter part, my lord.
Read.
Hello, can it be taken up after some time? He's online.
29 to be 29.
Maybe so this clearest bail application.
29, right? Just
Petitioner is on interim bail. Since September 49, 49, my lord. And the up-to-date case date was called for, and PM report and my lord FSL report was also called for. The case is that, my lord, the wife of the petitioner expired in the hospital, and twice she was admitted and she was seriously ill. And out of suspect, the sister-in-law of the petitioner has lodged in FIR, suspecting that there was some poisonous substance in the medicine, and doubting that the petitioner has mixed that. But that's why FSL report was called for. And
My lord, earlier we received the case diary, my lord, but it was sent for up-to-date, my lord. So up-to-date case diary must not received today, my
It's
lord.
not received.
Not received, my lord.
The case diary as called for, the up-to-date case diary along with FSL report was called for but not yet received. Issue reminder for the same. Interim passed on 4/9/25, extended till the next date of list.
22-1, my lord.
22/1. Okay.
Obliged.
Even the 30, my lord, search is submitted.
Lord, the anticipatory bail application and the interim bail was granted on 29/7, 2025. Because as per ISA, my lord, there is no any element of section 69 of BNS. Kindly peruse the FIR, my lord. Page number 16. সন্মানপূৰ্বক বিনীত নিবেদন এই যে মই এজনী ধৰাপুৰ চাৰিআলি বাসিন্দা হওঁ আজি 2 বছৰ ধৰি শ্ৰী দেৱেন্দ্ৰ যাদৱৰ পুত্ৰ বিকাশ যাদৱৰ সৈতে মোৰ প্ৰেমৰ সম্পৰ্ক চলি আছে বিকাশ যাদৱে মোক বিয়া পাতিম বুলি কৈ মোৰ সৈতে শাৰীৰিক সম্পৰ্ক স্থাপন কৰে 2 বছৰ ধৰি প্ৰেমৰ সম্পৰ্ক মিল এই বিষয়ে মই মোৰ মাক অৱগত কৰাত মোৰ মা আৰু দেউতাই তেওঁলোকৰ ঘৰলৈ গৈ মোৰ সৈতে থকা সম্পৰ্কৰ কথা কয় আৰু বিকাশ যাদৱৰ মাক আৰু দেউতাকক জনায় বিকাশ যাদৱ আৰু তেওঁৰ মাক দেউতাকৰ সন্মতিক্ৰমে আমি যোৱা এপ্ৰিল মাহৰ 22/4/2025 তাৰিখে আঙুঠি পিন্ধোৱা পৰ্ব সমাধান কৰোঁ এই আঙুঠি পিন্ধোৱা পৰ্ব দুয়োপক্ষৰ আত্মীয় তথা ৰাইজৰ উপস্থিতিত হয় আঙুঠি পিন্ধোৱা পৰ্বৰ পিছত যোৱা এপ্ৰিল মাহৰ 25/4/25 ইংৰাজী তাৰিখে বিকাশ যাদৱৰ এটা পথ দুৰ্ঘটনাত লখৰাত থকা প্ৰাৰ্থনা চিকিৎসালয়ত ভৰ্তি হয় ভৰ্তি হোৱাৰ পিছদিনা মই ভাবি চামি বিকাশৰ যাদৱৰ সৈতে চিকিৎসালয়ত চোৱা-চিতা কৰি আছিলোঁ ঠিক তেনে সময়তে এগৰাকী ছোৱালী আহি মোক নানা ধৰণৰ দাবী ধমকি দিবলৈ ধৰে আৰু তাৰ পৰা মোক গুচি যাবলৈ কয় আৰু তই কোন হয় বুলি মোক প্ৰশ্ন কৰে না টোটালি বেলেগ ছোৱালী আৰু একিউজে নাজানে সেইটো কথা তেওঁ নিজে সেইটো ক্ৰিয়েট কৰিছে হস্পিটেলতে চিন ক্ৰিয়েট কৰিছে মই আচৰিত হৈ চিকিৎসালয়ৰ মজিয়াত পৰি যাওঁ তেতিয়া মোৰ দেউতা আৰু মা আহি পুৱাত মোক মজিয়াৰ পৰা উঠাই আৰু কাৰণ জানিব বিচাৰে তেতিয়াহে আচল কাহিনী ওলাই পৰে যে সেইজনী পূজা দাস আৰু এই ছোৱালীজনীও বিকাশ যাদৱৰ প্ৰেমিকা হয় পূজা দাস নামৰ ছোৱালীজনীয়ে বহুতো বেয়াকৈ মোক গালাজ কৰে আৰু বিকাশ যাদৱ মনে মনে থাকে তেওঁ হস্পিটেলত এডমিট হৈছিল আৰু পূজা দাসৰ সৈতে লগ হৈ মোক যি পাই তাকে ক'বলৈ ধৰে তাৰপিছত তেওঁ গোটেই ফেমিলিটোৰ ওপৰতে কেছ কৰিছে 69 তেওঁলোকৰ লাভ ৰিলেশ্যন 2 ইয়াৰ্ছ ধৰি আৰু ৰিং চেৰিমনি হৈছে
Anyway, it's okay, no problem.
Since the circuit has already been submitted, Lord, let him appear before the trial court.
Kindly make absolute, my lord, the
Mr. Kolita and
interim prayer.
He was granted interim bail on 29/7/2025. The prosecution submits that investigation stands completed, resulting in a charge sheet.
Being search sheet number, my lord, 58/2025, dated 28/8/2025.
Considering the nature of the case and the completion of investigation, the interim bail is made absolute, subject to the condition that he shall not hamper or tamper with evidence and shall not cause any harm, harassment, or something to the alleged victim girl. Allowed and disposed.
Probably.
My lord, 31 also search is submitted, my lord.
My lord, I am on interim, my lord. I have appeared before the investigating officer, my lord.
Interim of granted?
Yes, my lord.
Appears to be a financial dispute primarily.
Yes, my lord. Civil dispute, my lord.
But we don't know. That will charge sheet will at the stage of trial. Last the petitioner was granted interim on 16/10/2025. Thank you. Charge sheet submitted. Victim girl hobo. Huh? Same one. Victim girl hobo.
Search sheet number.
Informant. Yes. CS number.
CS number 141/2025, dated 15/12/2025.
I will appear before the trial court, my lord.
Yes, I've made it absolute.
Yes, ma'am.
I've made it absolute. You can furnish bail bonds there.
Yes. Deeply aware.
Made PG Lordship. Miller, FIR is page 25. One of my employees committed suicide, Miller. I was thereafter provided interim protection also, Miller. By the order dated 7/11/25, Miller. Case study was perused on that day. Page 25 is the FIR, Miller.
He committed suicide.
He committed suicide, my lord. Page order dated 7/11/2025, if your lordship peruse paragraph 4 and 5, my lord. Upon perusal of the case, there does not appear there to be any direct implication of the petitioner in respect of 1031 BNF. And as per IO,
Salary was due, right? Some
they
salary
claim,
was
they
due.
claim it was due, my lord, but everything was in his head only, as the claim by my client, my lord. He said that because at 10 o'clock, the key was with him, that's why he was in the salon.
From the brother. Yeah, unfortunate again. Oh, he alleges murder.
Yes, my lord. Really is matter.
Okay, diary has
My lord,
been.
we have received the case diary, my lord. As part of the postmortem report, my lord, the death was due to asphyxia, my lord, as a result of antemortem suicidal hanging, my lord. That is true, my lord. And as part of the statement of the witnesses, my lord, they have implicated only to that extent that, my lord, some amount of money is due,
Was due.
due, my lord. And my lord, there was some heated argument between the, my lord, owner and the, my lord, deceased, my lord. This is the material so far collected by the IO, my lord.
Okay. No need to cancel, confirm it. Yet another tragedy. I go to
Three continuous case of suicide is.
Huh?
Three continuously suicide
Yeah.
cases.
Emotional
So much,
question. you know.
so much of.
We talk about IQ, but emotional question, stability is equally important
Very much.
because it determines how you handle stress, how you handle negative things. You know. And then if it is weak emotionally, if you are one may be very intelligent, but if you are emotionally not very strong, then you'll just panic when because life is full of ups and downs. You know. Life is full of life has many negative experiences as well as positive experiences. So this is the thing actually. We have
Negative
to
will always
train.
keep on coming. That type
People
of
should be encouraged to see counselors, take help. you know.
lordship, correct. Lordship.
Life is so precious and it belongs to our lives. Lives are interconnected. It belongs to our parents also. And to our mother also, as I said.
Family members, friends, everyone.
Yeah. The allegation in the FIR, no aspect of murder. Huh?
No,
So
as
far.
per the PM report, my lord, that is only there.
The
This is a non-continuous, my lord,
allegation
litigation.
FIR was lodged, FIR dated 10/10/25 was lodged with the allegation that there was an argument with the informant's brother with the petitioner as he was working in which the deceased was working in the salon of the petitioner in which the deceased was working over some unpaid amounts, but subsequently he committed suicide. It is alleged that it might be a case of murder also. The case diary has been, the petitioner was granted interim bail on 7/11/2025. And his statement is also available.
My lord, his statement, my lord, I have
Not sure.
No, Lordship, I have appeared before the
Make it absolute, but just asking.
But let him cooperate, my lord. It is not there, my lord, his statement.
It's not there.
Not there, my lord.
Okay, he'll appear. I'll dispose it of.
My lord, he dispose of, but my lord, he may be directed to appear within 7 days, my lord.
He'll appear. I'll direct him to appear. The case diary has been received. The learned prosecution, Mr. Borua, learned public prosecutor, fairly submits that the investigation has also revealed about some dispute over money, and the PM report indicates death by asphyxia due to ante-mortem hanging, suicidal hanging. In the circumstances, I do not deem it necessary to cancel the interim bail, which accordingly is hereby made absolute, subject to the condition that he shall render cooperation to remaining investigation and shall appear before the IO, making himself available for examination. Number 2, shall not hamper or tamper with evidence. Send return case diary disposed of.
I move.
Made, please, your lordship. Lordship, anticipated bail application
interim was granted, thereafter CD was called for.
Case diary not received, my lord.
Your Lordship, one more thing with regards to this case, can an information be taken that as per our instructions,
Yes.
after the interim was received, 2 days later, he was arrested in some other case, but the family is unable to say what is that case.
But that will be difficult on our part, my lord, to inquire, my lord, in what case he has been arrested, my lord. If he is not arrested in this case, because he cannot be arrested because in this case he has already been granted
This is
interim,
not
my
the
lord.
case.
But if he is arrested in some other case, my lord, that will be difficult on our part, my lord.
Murajar. no?
Murajar PS.
Karimganj.
Arrested in Murajar PS.
Karimganj.
Arrested in Murajar police station. Your Lordship. This
It's
case is
some
from
other case.
Murajar PS. But
There's a law now that when a person is under bail or something and then immediately he's sought to be arrested, then the court has to be informed. There's a judgment.
Yes, yes, no, there is a
law, but that would not apply here because he got an interim here.
Uh,
2 days later in different case.
different
Your Lordship.
case.
2 days. Not on that day, my lord, while he
Not
was
on the same
appearing.
day.
It should not be driven by malice.
Indeed.
That's the thing.
Indeed.
That's just because someone got bail here, arrest him in another one.
Indeed.
That actually the spirit of that judgment is this,
Indeed.
to inform the court.
Yes, no.
This
If he is arrested, my lord, on the same day, my lord,
Uh.
while he is appearing
Uh.
before the investigating officer, my lord, in connection with some other case, my lord, then only he has to be informed, my lord.
Yes, sir. The case diary as called for has not been received. The interim order stands extended, issue requisition for the sale. The interim bail stands extended till the next date of listing. Should I record that part? No, not necessary.
On 29/1, my lord.
Deep.
You can find out from the court, I think.
Indeed.
From court you can find.
Family and court will try to.
GR branch will be able to.
Deep your question.
Thirty-six, my lord, case diary not received, my lord.
May I please, your Lordship?
You file an additional affidavit.
Lordship, still I have not got the additional affidavit.
You have not filed.
I have not, sir. Okay, I will file, my Lordship. Kindly give a short date. In the meantime, I will file the affidavit.
Allegation of causing grievous injuries or something like
My
that.
lord.
Therefore, probably no interim is there. Anyway,
Let the case diary come, my lord.
Lordship, many times your Lordship call for the case, 5-4 times, my Lordship. May your Lordship kindly send a strong requisition, my Lordship. 3-4 months, my Lordship, they have not given any.
the case diary is not received. The learned counsel, Mr. Amin, has pointed out that the matter has been pending for diary for several dates. Comma. Full stop. I find the same to be true. The perusing the order sheets, full stop. The case diary shall be sent positively on the next day, for the next date. Full stop. In the meantime, the petitioner can file the additional affidavit.
Additional affidavit.
Leave the matter on.
Also called for.
29/1, my lord.
TCR may be called for, my Lordship. It's
TCR?
Certificate.
Oh, it's just
Certificate. As per my instruction, my Lordship.
Sorry.
Then the charge sheet may be, sorry, my lord, TCR may be, scan copy of the TCR may be.
Yes, my Lord. As per my.
This will not be relevant. Let it be. We should delete that, but the case is charge sheeted and scan copy is awaited, but not yet received. So issue press requisition for the scan copy of the case diary and charge sheet. In the meantime, it is the matter of work it out.
My lord, on 29/1, my lord.
Is it okay for you?
Can it be?
My lord, this scan copy has to be come, my lord.
Give him a little earlier,
But
maybe
then
27th or 22nd.
Then my 22nd, my lord.
22nd.
Deeply obliged, my Lord.
37.
May please, your Lordship. Lordship, as per the last order, this honorable court has directed them to provide for the fresh requisition of the injury report. But the same is not available before this honorable
Injury
court.
report not received, my lord.
His Lordship may kindly fix a short date and call for the injury report.
We call for case diary is available. no?
Case diary received, my lord, without the injury report, my lord.
It will be essential. Your good name, please.
Viscount.
Viscount, learned counsel for the petitioner. Submits that perhaps the injury report has not been received. fresh requisition may be sent. The diary has been received. Issue fresh requisition for the injury report. Can you retain the diary?
Better will return the case diary, my lord.
Whatever saves time, you can do that. 1 week will not make so much difference as such. Who is there? There may not be so much investigation also. But we can fix it on 19 or something. 19 or 20.
Difficult, sir.
It is 21, my lord.
21.
21,
Then I leave it to you whether to send it or
my lord.
okay. You'll keep it or send it back.
We'll keep it, my lord. Otherwise, my lord, it may not be again, my lord.
This
feasible.
will be retained. 21.
Much obliged.
Please, your lordships. Up to date CDs call for my lord. I was in interim, my lord, and I had already appeared before the IO, and my statement has been recorded on 2nd of December, my lord. But up to date CD is available or not, my lord?
No, what except of the accused.
Last kita case to sir.
No, no, आपको कितने की बिता चले?
তাহলে মই একটা টিভি কোন সিস্টেম ওয়ান আছে
7-11
পুরো কিছু আছে লাস্ট মেটা কিছু আছে মোর স্টেটমেন্ট আছে
নাই নাই
নাই কেন আপডেট হলো না 2nd of December
The case diary is not up to date, my lord.
You said
well
they were married.
yes my lord
They were married.
they are married man. But they are living separately because of their job.
No, this is not the fact, my lord. As far as statement of the witnesses, my lord. My lord, only court marriage was solemnized, my lord. They have done, my lord, his family members of the, my lord, boy, my lord. They have refused to, my lord, take her, accept her as a bride, daughter-in-law, my lord. Then, my lord, he is not performing the, my lord, social marriage, my lord, and he was prolonging, my lord. That is why, my lord, she might committed suicide, my lord.
Here for the informant.
Yes, yes, I'm appearing for the informant.
Would you like to say something?
My lord, I'm fully opposed AB because the victim
There's an interim order.
committed suicide because of the mental and physical torture of the accused person, lordship.
Diary has come.
The idea has come, my lord, but without the statement of the accused person, my lord.
My statement was recorded on 2nd of
You
December.
want that statement?
My lord, we'll call for up-to-date case diary, my lord.
The petitioner was granted interim bail on 7/11/2025. And pursuant to which he stated, he is submitted to have appeared before the IO in his statement record. However, the statement is not available in the case diary received. And the learned additional people seeks to get the case diary updated. Learned counsel for the, your good name, please. Your good name. R. Ali appears on behalf of the informant and opposes the grant of bail. So, the case diary may be returned and procured again with up-to-date investigation for the next date, list on
My lord, 28-1, my lord.
28/1. Interim shall continue.
28-1.
28/1.
Hello.
Case diary received, my lord.
We have filed an additional affidavit.
Okay.
And the last occasion, we sought time to file an additional affidavit, and accordingly we have filed. My lord, this matter pertains to a raid which is done by the anti-quackery and business officer. And my lord, my client, they said allegedly is a fake doctor.
Alleged to be a fake.
Alleged to be a fake doctor where he was practicing in Bongaigaon.
Achha.
And what they found that I was using one registration number of a different doctor,
Acha. Okay.
where we studied together in Russia. And I didn't complete it, he completed, and I was using the fake particular, the registration number. On the basis of that, there was a rate, and ultimately, my lord, they found there is a fake doctor. Now, accordingly, we came to the court. Our stand before this court that before the notice should have been issued under 35 of BNSS. That was the stand which we have taken while moving the matter. If your lordship, please look into the order that has been passed by this court on 19/11/2025. I'll just read this order, my lord, 19/11. If your lordship allows me to read this order, 19/11. Please look into, my lord, the third paragraph. An FIR was lodged on 3/11/2025 by one Dr. Abhijit Neox and Vigilant Assam Council of Medical Registration alleging that accused appellant has been fraudulently using the registration number of one Dr. Farooq Ahmed Duno, who is a medical graduate of Russia, and using his registration number, accused appellant has been practicing as a doctor in allopathy. On receipt of the FIR, the same was forwarded at Boigaon PS. Accordingly, Boigaon PS case number under so and so. Learned senior counsel of the accused appellant submitted police is visiting his house and threatening him to arrest without serving the mandatory notice under section 35(3) of BNSS. He submitted referring to various judicial pronouncement of this Honorable Apex Court. Once a case is registered against the accused person, non-bailable offence is mandatory on the part of the IO to serve notice under section 35(3) of BNSS. Therefore, he submits that an apparent violation of statutory provision has been committed by the IO in searching and threatening accused appellant without serving of the aforesaid notice. In view of the aforesaid, learned submit mandatory proof CRGC has been violated, is entitled to bail. On the other hand, learned APP for the respondent submitted he does not have any instruction as to whether notice has been issued to the accused appellant or not. In view of the aforesaid, he prays for some time, procured an necessary instruction from the IO. In view of the courts of the matter can be considered on exit after completion of instruction by learned APP. Let the matter be fixed on 26/11. It is the IO shall not take any coercive steps such as arresting the accused applicant in the instant matter till an exit of hearing. So I was protected. Now thereafter, my lord, a notice has been served under 35 BNSS. Please take my particularly my application additional affidavit which has been filed. Okay. Which has been filed on 17/11/2025. 15th of December. Please take that 15th of December two additional affidavit has been filed. Kindly look into my page 21, my lord.
Yeah.
21. This is the IO has served a notice to the petitioner under section 35 only on 29/11/2025. The lordship looks into it. And this order was passed on 19/11/2025. Got it, my lord? The 35. Accordingly, on the basis of this notice, my lord, I appeared before the IO.
And then
After 19 days, notice was served. After 19 days, the notice was served. And my lord will kindly see that notice was on 29/11/2025. And if your lordship looks into it, my statement which I have made in paragraph 3, my lord.
of the affidavit,
Oh, yes, at page 18.
paragraph 3.
Page 18. Paragraph 3, my lord. From the FIR revealed that the informant lodged FIR on 3/11 with CID, registered on so and so, and there are same was forwarded to Boigaon Police Station, which were registered on 8/11 as Boigaon PSK. Therefore, police ought to have some notice of deponent under section 35(3) of BNS in compliance. Honorable Apex Court direction within 2 weeks from the date of registering the case as a punishment of the offence is up to 7 years of imprisonment. But only after deponent approached the Honorable High Court by filing a bill, and the Honorable Court was pleased to provide interim protection. By order, the police issued notice. Deponent under section 35(3) directed deponent to appear before police on 30/11. In compliance with said notice, the deponent appeared and got his statement recorded. Department also executed a bond stating that he will appear before police as and when required. Now, my lord will kindly see at page 22. This is the bond. My statement has been recorded. As and when it is necessary, they said we will be called. So now, after that, my lord, we have filed an additional affidavit.
I'm on the affidavit only.
Yes.
This is the
Now-
annexure A of the affidavit.
Now, if your lordship looks into
Annexure B.
35 3, my lord,
Give me the
of BNSS.
35. BNSS. Without calendar, this is not. I was in- Very good.
My lord will kindly see
Yeah, you can be.
35 3, my lord. The police officer shall in all cases where the arrest of a person is not required under subsection 1 issue a notice directing the person against whom a reasonable complaint has been made or credible information has been received or reasonable suspicion exists that possible kindly 35 3.
Yeah, please go on.
Lordship got it. That a police officer shall in all cases where the arrest person is not required under subsection 1 issue a notice directing the person against whom a reasonable complaint has been made or credible information has been received or reasonable suspicion exists that he has committed a cognizable offense to him or as such other place has been specified in notice. See 5, my lord, 35 5. Where such person complies and continues to comply with the notice, he shall not be arrested in respect of the offense referred to in the notice unless for reasons to be recorded, police officer is of the opinion he ought to be arrested. Now, what my submission before this honorable court is that my lord, the 35 BNSS 3 that was not served apparently. We appeared before the court and
Then
we
it-
said that
then
this
it was
has
served.
yes, thereafter it was served and my statement is recorded and bond also is executed, my lord. So at this stage, what my prayer before this court is that whether my custodial detention is required or not. In view that my statement has been recorded, there is a bond which has been executed. If you see, my lord, the contents of the affair, of course, my lord, he appears to be an alleged fake doctor. Now, my statement totally has been recorded and they have, a bond has been executed also. In compliance of section 35(3), my statement is recorded, they have called me, my lord. At this stage, whether my custodial interrogation is required. That's the point before this court, my lord.
Conditions not violated.
And I have not violated any of the conditions.
That's fine.
I don't want to trouble with all the judgments, my lord, that is related to 35. This is only a custodial interrogation, whether my detention is required at this.
My lord, we have received the case diary, my lord. We have
1 minute.
Yes, my lord. My lord, regarding submission of my landed senior friend, my lord, regarding 35 notice, 35 3 notice and PR bond, my lord, I have checked from the case diary, my lord, it is true, my lord. My landed senior friend statement is true, my lord. 35 3 notice was issued to him, my lord, and
Yes.
pursuant to that he appeared, my lord, statement recorded, and he was released on PR bond, my lord. Now, my lord, as per the, my lord, materials in the case diary, my lord.
Without notice, person can be arrested, but reasons have to be given.
Yes, my
Proper
lord.
reasons have
Yes.
to be given.
Now, my lord, since he was in my lord already in my lord, no coercive action, my lord. That is why probably my lord, my lord, police has not arrested him, my lord, and he was
Yeah,
released on
police
PR
not
bond, my
arrested.
lord. Now, as far as the materials are concerned, my lord, there are materials, my lord, in this case diary, my lord. But my lord, there are some part of the investigation that has to be carried out, my lord. For that, my lord, I just placed the my lord case diary, my lord. Lord, has just perused the only one paragraph, my lord.
How, he's a young person or?
55 years. 55.
Oh.
This part of the investigation is crucial, my lord. Paragraph 10, my lord, Lordship may kindly peruse.
Page 5.
No, paragraph 10, my lord, that.
Paragraph 10. Yeah, that means they have written to the National Medical Council.
Yes, ma'am, that
And
report
the
is,
waiting, that's true, because
Yes.
they will be able to say whether, because now it's an allegation which is being investigated.
yes, my lord.
Some materials have been found to
Yes.
some in support of that, but ultimately, it's, whether his medical license is valid or not, that only that.
No, my lord, he himself
top-
stated, my lord, he himself stated, my lord, that he has not completed MBBS, my lord. Without completing MBBS, my lord, he returned from Russia, my lord. And after that, my lord, he is practicing, my lord, prescribing medicines, injection, etc., my lord. That is the, my lord, allegation, my lord.
So in view of this, what do you propose? Keep it pending or something?
No, that part I leave it to your lordship, my lord. Because there is also an objection from the IO, my lord, that is a part of the objection, my lord.
That can be done. Yes, objection from the IO. Their objection.
Leave it to, আৰু কেইটামান বস্তু আনিব।
The report is to be brought. I think then your lordship has to
If
look.
you are agreeable, that can be done, it will be fair to both the sides. I think. Let them get the complete, let them get the, because he has written himself, I think.
Unless he doesn't operate and person, patient has died, that's a different thing. Normally.
In the meantime.
In the meantime, normally, my lord, I am telling your lordship that today also I know insulin, there are different type of insulin. We also know for a diabetic patient what insulin has to be given. Medicine also we have a fair knowledge, but without a doctor, being a doctor, also fair idea is there who is suffering from illness.
Yes, yes, he studied also.
Yes.
But unfortunately,
He
could not
studied,
complete.
but unfortunately,
But he
that's
should have
yes.
completed it instead of
Correct,
getting into
correct,
all
your
this
lordship,
mess.
right.
You know.
But what my submission is that, my lord, he will definitely cooperate. He's not that the bond has been executed, my lord.
I think because the IO has this it is very persuasive. I find
Yes.
that this verification and these documents are vital to conclusively establish the allegations of this thing. It's very fairly essayed, this actually.
That is why, my lord, I have placed this, my lord.
Yeah, bail petition should not be kept pending for long generally, but the thing is that this can be that we continue his protection for some more time and wait for it. That can be done.
And your lordship
are
can
agreeable.
indicate more, your indicate with my respectful submission is up to the court. If my cooperation is required, my statement again can be recorded, whatever is there.
No, he has signed bond, no need.
Yes, that's fine.
No, no, he signed a bond.
Yes.
The petitioner was granted, heard, he does, Learned Senior Counsel, R.J. Bogart. Yes, the petitioner was granted interim bail on 19/11/2025. Pursuant to which he appeared before the IO and a statement has been recorded. And he has also executed a bond. The petitioner side has also filed an additional affidavit. It is Learned Senior Counsel submits that despite the applicability of section 35(3), the BNSS, the notice was not given, and only after filing of this bail petition, the notice was given, pursuant to which he appeared also, and the bond executed as stated above. The case diary has been received. The Learned additional BP has brought to the notice of the court statement of the IO in his elaborate bail objection that that the investigating agency has sought from the National Medical Commission information regarding the academic credentials of the petitioner, but the said information is awaited, and that said documents are essential for the investigation, final investigation into the case. In the given facts and circumstances, it would be prudent to keep the bail pending, extend the interim protection and wait for further materials in the case diary in the form of, especially the aforesaid document referred to. Return back the case diary and to be procured again after with updated investigation, including that information if any from the NMC, National Medical Council. In the interim bail stands extended in the next day. You can give it in the last week of January.
30, my lord, 31. We'll return the case diary, my lord.
Oh, case diary return. People go to many people. It's common in developing countries. They because they cannot afford actually. That even the doctors fees. That many people just take medicine from pharmacy.
Yes, correct.
Just,
Right.
And they dispense
right.
also, although they are not supposed to.
Correct,
actually, but
right.
they dispense.
It becomes very expensive.
But projecting oneself as a suppose if it is
And
true,
my lord, we are
that is
lucky in
highly
India.
illegal.
India, we get appointments. But in outside, we don't get appointments also for months. So your lordship is rightly said, they go to a pharmacy and they get medicine. Because you take 3 months, 4 months to get an appointment, unless it is very, very serious.
That is also dangerous. Any kind of self-medication is also dangerous, as you said. Different doses of the same thing. Even paracetamol.
Number 70, timing. 70.
70.
Agora,
In this case, my lord, scan was called for, but that has not been received, my lord.
Well, this is the third occasion, my lord. I am only 47, 48 one now. This is the third occasion, my lord. And more than 4 months today. Started already 5.
Just a minute. 69 obviously. 7, okay. Yes, sir. Or pending for some time.
63 one what you was condition. This is my case. I'm not on merit, but already trusted 5 4 months already gone. 63 one what one.
Yeah.
And this one. And the
63.
63 one what my lord, 47. And thereafter you also will find 48 notices from 79. Same by the same sort of that. It's just one of the orders you lost it for 30 night. The similar circumstances. And
Conspired. Yeah, it has some grounds, but ideally.
but particular
Ideally,
particulars must be.
little more. Anyway.
Particulars must be well, madam. I'm just giving 48, paragraph 48 of the case.
48, this is also same.
I'm just giving my.
Same.
Paragraph, no, 48, paragraph 48. Yeah, no, no.
Yeah, this is how we learned from this decision. That, grounds of arrest,
Everybody
reasons
is
for
learning. We
arrest
are also learning about it.
are different. No, yeah, not you. I'm talking about me.
Your lordship will find, my lord, the middle portion, paragraph 48, my lord.
Yeah.
Page 282. 283. Book is given, my lord. Then your lordship will find these reasons would come, your lordship got it, my lord. The last part about 6 4 line above mine. These reasons would commonly apply to any person arrested on charge, so detained in hand to the detention officer, which is necessitated the arrest of the accused. Simultaneously, ground of arrest informed in writing must convey to the arrested accused person facts, basic facts on which he was being arrested, so as to provide him an opportunity of defending himself against custody in remand. That the ground of arrest would be invariably personal to the accused and cannot be equated with the reason of arrest, which are general in nature.
Yes.
Now, in Kashir Reddy case, your lordship latest one, the law in England and USA also aided that is also there, your lordship, paragraph 28, 29 to this one.
But frankly speaking, this cannot be said to be total non-compliance, though it should be little more, I agree, but not a case of any. So,
One note already your lordship last time we have given mine. LDP might have purpose, no purpose of further custody integration, but merit also might have. Subject of my learned friends, I think he will be fairly also admitted.
My lord, my only submission is that since my lord, the scan copy of the record is not before us.
That is, I am on, not, I am only 47, 48. I don't know.
But 47, 48 notice also, my lord, we have to verify from the scan copy record.
Well, that,
Suppose
both we have taken.
it is, as I said, even this
Yes,
must be
this
in
is
the
one
notice.
vote, but both
But-
copy I have there.
but,
Original one as well as
It's
English.
completely bland. No, this has some details, though some more details would have been helpful anyway. Madam, you are appearing for the
For the
informant.
informant.
Yes, make your submission, please.
Sir, like my submission is the same that all the accused are influential persons and the applicant number one is already having some criminal records also. He is involved already in POCSO matters. He is a very influential person and he can like manipulate the evidences and the witnesses.
Every condition we can give, there is no problem. It is
So once they
something-
are already,
If I violate,
once
madam, I-
already accused number 13 was released on interim bail. Again, he has created nuisance. Again, FIR has been filed against him and he was again arrested.
We have no relation with him, madam. It is a
The
individual-
all are of same
No, we are complete.
same group.
This has to come from which court?
Sorry.
Morigaon.
No, from Morigaon.
No.
We can let's get it then for a few days. The third learned senior counsel and RJ Bora. Your good name, please, ma'am.
My name is K. Verma.
K. Verma. Appearing for the informant full stop. The learned senior counsel has submitted that at this stage when the case has already been charge sheeted and pending at the stage of appearance.
Not yet commit yet, my lord.
Appearance.
Charge not yet been framed by.
Yes.
Charge not framed by.
And
It will take time under
pending
24.
for framing of
My
charge.
PWs.
The
19
much
PWs.
purpose may be served by keeping the accused persons in custody.
4 months by
There's
this time.
also drawn attention to copies of the notices under 47, 48 BNSS and submit that the same would not be sufficient compliance with these provisions in terms of the settled law. The case diary scan record was called for, but not yet received. This is the first day today, right? No, not the
This
first.
is third time.
Not the first day.
You have
Okay,
first
second.
16, 12,
The
then
second-
6, 1, then
second.
today is third one.
Second day.
Third today.
The scan record was called for from the court of the learned session judge Morrison, not yet received. Ms. Burma, learned counsel appearing for the informant submits that the petitioner number one herein is an influential person. And he might intimidate the victims and other witnesses. Issue a fresh reminder for the scan record of sessions case number 154 of 2025 from corresponding to Bhuragaon PS case number 49 of 25 from the court of the learned session judge Morigaon. They will get it immediately after the petition. Then we can dispose it. Burra, we will suggest a date.
If it does not come, my lord, your lordship may pass order. my lord.
Then I will see.
Today is the third time.
Then we'll see. We'll see. 20,
220, man.
no, 20 or just guide me with the date.
Scan copy, my lord, only it is registry will bring, my lord.
Couple of days will be.
Immediately after vacation.
They're also closed couple of days.
Yes, my lord.
You know, they'll reopen on, I think,
On
7th.
Reopen 19th.
16th. No,
21st.
district courts will open on 16th. It will be realistic to fix it on 20, says first or second, 22nd. 22nd.
22nd.
22nd, 22.
If scan copy does not come, my lord, your lordship.
We'll see,
If
we'll see.
Oblast.
May I please lodge? In a malicious affair lordship lodged by my lord, one lady lordship. Charge sheet was submitted lordship showing the petitioner absconder lordship. My lord, his charge sheet was, this affair was lodged, my lord, on the grounds, my lord, the against her husband, my lord, my brother lodged FIR, my lord, her husband was, my lord, criminal lordship. In 2 cases, my lord, he was convicted lordship. In our case also, he was convicted, my lord.
After coming from my lord jail, my lord, a false case was made out, my lord, alleging my lord attempt of rape of his wife, lordship. Kindly see the FIR, lordship, at page 12. My lord, page 12 is the FIR. My lord, she is Parveen Sultana, wife of Mohsin Ahmed, my lord. Mohsin Ahmed was convicted in 2 cases, lordship. In our cases also, lordship. Now, this is a case, my lord, allegation, my lord, kindly see at page 12, lordship.
Anyway, that's in plan.
Lordship.
Charge
In
sheet
that
is-
case, charge sheet was submitted, lordship, showing me external lordship. Someone was issued from the learned magistrate, lordship. I, my lord, submitted application, my lord, for granting time through my council, lordship. And those applications were sometimes, my lord, granted, lordship. Time was allowed, lordship. In it, kindly see at page petition, page 27, lordship. Lordship.
Long time for a appearance.
Yes, that case, my I was not able to appear, lordship. Showing cause of absence, lordship, application was allowed. Then, my lord, on page 28, lordship, I was absent. A step was taken, my lord. Application was filed, my lord. That was also granted, lordship. Now, next date, lordship, at page 30, lordship. Page 30, I was not able to appear, lordship, submit application, lordship. And a non-valuable warrant was issued, lordship. Again, that I have come before you, lordship, for protection, lordship. On the other hand, the case is, my lord, session tribal case, my lord, section 376 by 511 is there, lordship.
It's a case of 2020. So entire investigation he was not cooperating. But page 34 lordship, that records lordship file rejected. The TCR shows that the magistrate took cognizance of offences under section 457, 376, 511, 323 IPC and issued summons to the accused person, wide order dated 4/2/2021. And thereafter, in the last more than 4 years, the accused did not appear before the court of first class. The case record also shows that wide order dated 2010-2022, the learned JFC reflected the Honorable Session Judge Morigaon wide order dated 13/10/22, passed in a BA number 590/22, rejected the anticipatory bail application of the accused person. Yet thereafter, the accused person did not appear before the court of learned JFC Morigaon. Presently, warrant of the arrest has been issued against the accused person, and the accused is yet to appear in the court of learned JFC. So, lordship, entire investigation is not cooperating. Trial is pending because it is not cooperating to the trial also. So, at this stage, he is seeking anticipatory bail. But my humble submission is that I am opposing the at this stage of his prayer for anticipatory bail, lordship.
My lord, it is not 4 years. Kindly see page 28, lordship. The learned magistrate's lordship order, lordship. It is a 1 year, lordship. 1 year without showing, my lord. Applications were submitted, my lord. Kindly see at page 28, lordship, the order. The result of the case record reveals that the accused has been absent since the last 1 year without showing sufficient cause. Further, the snake case is at the stage of appearance since the last 1 year, lordship.
Will he appear regularly? No.
My lord, submitted application through my counsel, lordship. My lord, I have been instructed that he did not appear. He submitted an application, my lord. The learned magistrate said that you will be remanded because it is a case of session tribal case, lordship. That is why, my lord, his counsel submitted application, lordship. Now in such a circumstances, lordship, someone was issued, lordship.
He could have appeared actually. Interim order is there. I noticed now.
Yeah.
Interim order is there. Where is the interim order? There's no interim order.
No.
We can have it.
Interim is not
Okay.
there. Now, what I am submitting, lordship,
You can have it.
my lord, what I am submitting in such a case, my lord, in session tribal case, lordship, when the someone was issued, lordship, they on apprehension in such a case, in that case also, my lord, the accused was absconding, lordship. This honorable court has granted bail, saying that there is a genuine cause of that he may be remanded my lord, by the magistrate back, because my lord, the
I think-
judicial magistrate is just committal court lordship, cannot grant bail lordship. So in my case, that apprehension is also there lordship. So it is, if I appear, my lord, I may be protected, I may be granted bail, I'll regularly appear before the learned tribunal. Okay, the trial will be progress lordship.
M.H. Hamid, learned counsel for the D.P. Goswami. You are appearing for the informant.
Informal lordship.
Okay, sorry, please. The wrong, by mistake we wrote this actually. If any, please.
Yes, Lordship, the case is pending before the court of CJM and has not yet been committed, Your Lordship, as the offence are session tribal.
Yeah.
So I leave it upon the court, Your Lordship.
So that is, well, she may not
No, that's
object
fair.
lordship.
No, fair.
Trial will be proceeded lordship.
She's been very fair, it's okay. M.H. Hamid,
I will
learned
regularly, my
counsel
lord,
for this thing.
cooperate with the trial.
Ajay Borua, learned additional PP. Your good name, please.
HG Daisy.
H.G. Daisy, learned counsel appearing for the informant. The learned additional PP opposes the grant of bail. However, the learned counsel for the informant submits that the case is at the stage of appearance at present. Order regarding bail may be passed as per law by the court. Now peruse the annexed documents and orders of the learned court below. The case is pending for appearance and committed. It is pointed out by the prosecution that due to the absence of the prosecution, the petitioner in between, the matter got delayed. It is submitted. In this context, Mr. Ahmed submits that the petitioner shall cooperate with the trial. In the circumstances, to facilitate the progress of the trial, I allow this petition and it is directed that 50,000 is 10 to the like, to the satisfaction of the concerned learned court, GMFC Morrigan, and subject to the condition that he shall not abscond. Number two, he shall appear before the learned court below. Now, number three, he shall be available during the trial. He shall not hamper or tamper with it. Allowed and disposed.
Much obliged.
Wait, please, Lordship. My lord, here, your Lordship will find the complainant, my lord, then and the petitioners are lawyers from the Jorhat Bar Association.
That's
And there is a, my lord, extramarital affairs led to this FIR. And we have been protected by giving an interim orders, my lord. And as per the, my lord, interim orders, my lord, we have appeared before the learned, sorry, my lord, IO, my lord. And also we cooperated with the investigation, my lord. The complainant also filed an application there in before the session just for DNA test. For DNA test, my lord.
DNA.
And also, my lord, termination of pregnancy under the Termination of Pregnancy Act, my lord. They are rejected, my lord. So the application has been rejected of the complainant. So basically, it is, my lord, the question of rape doesn't arise at all. And your lordship will find that earlier also concept page 10 is the notice by the complainant itself, my lord, asking last paragraph, my lord, what her grievance is this. That is at page 12 onwards, my lord. The legal
notice sent by
the complainant, my lord.
Informant.
And here everything has been written that both are the practicing lawyers, how they have been met and how they have gone through. That is, so the petition number 1 is concerned. Petition number 2 and 3 is concerned. They are the lawyers also, what they said, they accompanied the petitioner and they have straightened them below. So that is one. And they said that to pay monthly maintenance of rupees 40,000, to bear all medical expenses of the present so-and-so, so-and-so, to pay compensation of 5 lakhs.
Like that.
So the ballot. So therefore, my lord, the question of 69 doesn't arise at all, my lord.
Investigation.
So we have received the case there, my lord. There are allegations of, my lord, rape, my lord, and forceful abortion against the petitioner number 1, my lord. Against the other 2 petitioners, my lord, there are allegations of threatening, my lord. Threatening the, my lord.
They have appeared, all of them.
All
They
of
have
us
appeared, my lord. Only, my lord, medical report of the victim, my lord, that had yet to collect, my lord.
What do you say? This
Medical report. Oh, definitely.
Lordship ने kindly
এইটো দি দিয়ক হে এইফালে
Okay, I will.
one is, my lord, the application filed by the complainant, and that is the order passed by the learned additional session judge Jorhat, my lord.
Medically high risk soldiers used.
High risk we got up because of, my lord, when filing applications, my lord, for termination, my lord. It is the complainant she filed, because definitely, my lord, if you have a, will be physically, after a certain period, my lord, it is not advisable, my lord. So that is why his prayer for so-and-so has been rejected also. Also, my lord, they have also filed an application for DNA test also, my lord. DNA also rejected, the reason being because of the investigation is going on. Now the search sheet has been filed. If, suppose if there is she admitted that the question of rape doesn't arise at all. It's a consent thing.
Anyway.
The lawyers, my lord, I should not.
It's okay, no problem. So, Pranbur, learned senior counsel. And D.P. Goswami, Ajay Burwa. The petitioner was granted interim bail on 25/11/2025, pursuant to which they have appeared before the investigating officer at Jorhat, and their statements have been recorded. The case diary has been received and placed before this court. I perused the relevant portions thereof. This stuff. Seen the progress of investigation. In the circumstances, and also considering that the petitioners have rendered their cooperation to the investigation, do not deem it necessary to cancel the interim bail, which accordingly is hereby made absolute, subject to the condition that they shall cooperate with the remaining investigation and shall not hamper or temporarily evidence. Return is that the petition stands.
I'm obliged for that.
Oh.
May please your lordship.
It was
43 to 7.
Lordship, interim bail was granted on 3/12/2025, and accordingly, that is the petitioner recorded statement on 9/12/2025 and 24/12/2025. Two occasions CID has, that is called the petitioners and recorded a statement. The entire affair, place of occurrence in the Canara Bank Ulubari branch, and main accused has been granted bail, and I was working in the Canara Bank Dispur branch, lordship.
okay.
The entire, that is the affair, did not disclose anything that I have committed certain wrong thing. But one thing is that there is one word, because main accused is my wife, that's why I have made conspiracy in committing such things, lordship. That is the allegations against me. And I'm cooperating with the investigation.
Petition to CID.
CID.
Can it be taken up some other day, my lord?
CID?
We could not go to the, my lord, case diary today, my lord.
Okay, you have also been very
They are on interim.
overloaded.
We'll retain the case diary, my lord, immediately after vacation, on any day, my lord.
The the petitioner was granted interim petitioner one, granted interim bail on 3/12/2025. Pursuant to which he stated to have cooperated in investigation. It is submitted that main accused and some other co-accused have already been granted bail. Case diary has been received, but learned prosecutor, learned additional team submits that due to time constraint, you could not go through it. It took some time, which is allowed. Full stop. Case diary be written, list on 19.
My lord.
Interim self extends the next day. Now very much.
The case diary was called for before.
Case not received also. Interim done, interim.
Interim may be continued.
Yes, sir. Case diary is not received, issue reminder. The interim bail stands extended till the next date of this list on
28/1.
Not matter. One more matter we can take first.
My lord, item 46 also out of the same.
45 and 46 out of same. Yes.
Okay, I'll take your matter.
44 and 46.
44 and 46.
Out of the
Same-
same case diary.
Same.
46. You are on interim?
My lord.
Mm.
Both the matter may be tagged, your lord.
Take them. So interim may be extended. Same date.
Same
28
date.
one.
Same date.
28/1.
21.
28/1. Take a short break.
Obvious.
Break.
48.
56. 48. 48.
May I please the Lordship? Lordship, this is a anticipatory bail application, Lordship. Lordship will find the FIR at page number 10 and the vernacular is at page number 14. Lordship, here in this case, Lordship, the FIR has been, the informant is the brother of the deceased who happens to be my wife. Lordship, if Lordship, like,
Just a minute. Brother of the deceased?
Lordship.
Yes, sister.
Okay. Lordship. Lordship, in my humble submission, the allegation that has been alleged in the FIR is false, Lordship. Lordship, contrary to this, Lordship, I am the victim, Lordship. I have lost my wife. I am at a loss. Lordship,
They had got married.
Yes, Lordship, page number 6
Court
is the
marriage.
marriage certificate,
Court
court marriage. The actual fact is different. Lordship, if I may be allowed, Lordship.
Yes.
Lordship, what has happened is this. Lordship, since I stay in Nalbari and my wife, she stays here in Guwahati. I don't know what has come in the FIR, in the case diary, Lordship. Lordship, in
Whatever
the
your
particular
instruction.
place where my wife has taken her last breath, Lordship, in that, this is a rented house, Lordship, where the informant, the mother of the deceased and the sister of the deceased, they all used to stay together in that rented house. And for a reason best known, that was on that fateful day, it was the first day of Durga Puja. And Lordship, on that particular day, Lordship, surprisingly, none of the family members were present at the house, and my wife have taken this drastic step. Now, Lordship, coming to the aspect that I have, if we come to the FIR, Lordship, the direct allegation has been alleged on me that, Lordship, I have demanded an extortion and dowry of rupees 5 lakhs, and I was delaying the traditional marriage, which I completely deny, Lordship. Why? Lordship, actually, as a matter of fact, Lordship, the family members of my wife, they were against the court marriage or the relationship of me with my wife. They were pressurizing my wife to divorce me, to end the relationship with me. I don't know whether CDR has come in the case diary or not. On that particular day, Lordship, I was calling my sister-in-law, that is the sister of my sister of my wife, the deceased, and my wife. I was constantly in touch with them. I was in fact begging the family members of my wife to allow me to meet her, but they had completely stopped me from meeting my wife. And perhaps, Lordship, my wife has taken this drastic step. Now, Lordship, my humble prayer is this, Lordship. Lordship, if I may be allowed to give my statement recorded, Lordship, the dimension of this entire case will change, because I can prove that the family members of my wife, they were harassing my wife to end the relationship with me, Lordship. And Lordship knows very well, Lordship, that in the recent case of Abhinav Mohan Delkar, this 2025 case, Lordship, the onus mere allegation, Lordship, it has to suffice with the intention and mens rea, Lordship. In my humble submission, Lordship, I am innocent, Lordship. I have suffered a lot. I am at a loss. Till today, I am mourning the death of my wife, Lordship. Lordship, when my wife was alive, the family members, the informant, they had harassed me. Even after the death of my wife, they are harassing me like this, Lordship. I may be allowed to go on bail. I will cooperate with the investigating agency. I will bring forward all those materials that are available with me to prove that instead of me harassing my wife, it was the family members of my wife, they were harassing my wife.
You want to show some judgment?
Lordship.
Yes. We have received the case diary, my lord. That is what my learned friend has stated. It is his, my lord, story, my lord, story of the, my lord, that is the accused petitioner, my lord. Now, my lord, admittedly, as because, my lord, there is a, my lord, there is marriage certificate annexed, my lord.
There are 30 and 40, Lordship.
Yes, go ahead.
Yes, my lord, because, my lord, one, my lord, that is marriage certificate is annexed, my lord. So, my lord, though, my lord, there, my lord, social marriage was not commenced as per the, my lord, traditional way, my lord, but they are the married husband and wife. Now, my lord, the allegation in the FIR states that, my lord, that is they are going for, that is the, my lord, that is the social marriage ceremony, my lord, that is a traditional way. In the meanwhile, the problem arises because he is demanding money, the sum of rupees 5 lakhs. That was the allegation in the FIR. Now, my lord, where, my lord, she resided in Guwahati, my lord, in one place, my lord, that is a, my lord, rented premise, my lord. They stated that along with her sister and mother, regarding the part of whether mother was there or not, my lord, that part is not come out from the investigation. But, my lord, that is, my lord, that was, my lord, that informed by the, my lord, the landlord, my lord. And the, my lord, the person, I am not saying about the, my lord, that is the informant and the, my lord, the victims, my lord, that is the mother or other persons, but I am relying on the, my lord, that is the person who witnessed the situation and immediately informed, my lord. What she stated, my lord, may kindly peruse that, my lord. That is also stated that, my lord, that is this person. I am not on that part, my lord, because, my lord, he is a married, my lord, husband, my lord, as per, my lord, that is the after Special Marriage Act, my lord. So, my lord, he was very much present in sometimes in living together. Those parts are there, my lord. So, my lord, that is the investigation is at very nascent stage, my lord. So, at this stage, my humble prayer before your lordship is that, my lord, and my lord, that is the FSL report, my lord, yet to, my lord, come, though, my lord, this PM report is there. So, my lord, till then, my lord, that is his prayer for anticipatory bail may not be granted. My lord, may kindly peruse the CD, all relevant parts I have flagged.
My wife, I happen to
admittedly, my lord, she was his wife, my lord. We are not contradicting that part, my lord. But the question arises whether, my lord, that is the demand of that, my lord, particular sum of money is there or not, my lord. That is in question, my lord.
For argument's sake, Lordship, if we believe that I had demanded an amount of rupees 5 lakhs, then what the informant was doing, everyone knows, Lordship, that it is a illegal demand and I can be booked, Lordship. But
my lord, at this stage, my lord, with the prima facie, my lord,
all these things came up after the death of my wife. It is a concocted story, Lordship.
That Mansi Basumotari.
Yes,
Right.
my lord.
Where is your statement?
My lord, I have flag mark, my lord. I have flag mark, my lord. One name, my lord, I have, my lord, written there, my
Complainant.
lord.
No, not the.
Thereafter, my lord, maybe try to define.
Complainant is Labojit Talukdar.
Yes, he is the brother, my lord, brother of the deceased.
He is implicated. Bas Burman.
And regarding the traditional marriage, lordship, my wife was the earning member of the family. And if she had left the household of her family members, they had to get a setback of
Just a minute.
lordship.
Mrinal Basumotari, your statement.
Yes, my lord, there's Minal Bosumotari, my lord,
rented
and another person.
landowners.
Because, my lord, that is, my lord, they are the persons, my lord, who come to know about the incident, my lord.
They were the first person perhaps to notice.
She does not know about her personal relation, personal.
Yes,
life.
my lord, then thereafter, my lord, another one is there, my lord.
Nena Hazom.
Yes, Naina Hajam. Naina Hajam. Star witness.
He has stated about their marriage.
And my lord, he
used to come.
reside there, my lord. That part is also there.
Maze maze ahe nahi.
Yes, his lordship, this is
Yes,
an
my lord.
admitted fact. I used to go there, but
It is not like that, my lord,
The
there is a, my
problem
lord,
arose,
because of the
lordship.
marriage, my lord. There is a, my lord, there is a conflict between the families and he was there, my lord. That part is also, my lord, reflected
that
there.
does not subject.
Because of that, my lord, that is, my lord,
Lordship, in my humble submission.
জনাৰ মতে
yes.
মিনমণি কলিতা বুলি ল'ৰাজনৰ লগত তাইৰ বিয়া ঠিক হৈ আছিল আৰু সি মাজে মাজে ৰুমটোত আহিছিল।
That part is important.
I don't know, lordship,
That
why
part
my
is
learned
important.
friend is raising that point, lordship, in order to satisfy 108 lordship, BNS lordship, it is admitted fact, I was the husband, I am admittedly saying I am the husband of the deceased, I used to go there, but the problem arose when the family members registered, they were forcing my wife to leave me, lordship. So when my wife and me, we were deeply in love with each other. How
These
can
two
we?
persons, Mrinal and this, they're the landlords.
Yes,
Landlords.
yes, man, yes.
Sorry.
Lordship. So we were deeply in love with each other, lordship. This is admitted fact. And when the family members, and there are many reasons, because my wife was the only earning member of the family, lordship. The informant, he is an unemployed person, and my mother-in-law is an aged old age lady, and the sister, she is still in school, lordship. So in a way, lordship, there were so many factors which promoted the family members of my wife to pressurize her to leave me when she was not when she was not complying with their pressure, lordship. She might have taken this drastic step, and lordship, if at all I am to be blamed, lordship, she might have she would have left a suicide note In this case, Lordship, there is no suicide note.
Not always, depends.
Lordship,
Every
And
situation.
my lord,
Lordship,
one
my
my lord, that is
submission
a
is this,
objection
Lordship, I
is
am-
also
I am
filed by the
interested,
IO, my
Lordship.
lord. There, my lord, another one objection prayer is also filed by the IO, my lord. That is also I have flag mark, my lord. There, my lord, in this, my lord, objection note, my lord, there is a last part of the objection note, my lord, may kindly peruse, my lord. Some other things, my lord, he reflected, my lord. That will come after the FSL report, my lord. Whether it is there or not, my lord. Another reason, my lord. As because, my lord, it is, my lord, still investigation is going on. I am not disclosing, my lord, my lord. May kindly peruse, my lord.
My part of the story is not being heard till now, Lordship. The IO have investigated and my statement is yet to be recorded, Lordship. If I may be allowed to record my statement, Lordship, my side of the story will also come up, Lordship.
This, heard, you, Mr.
Dr. P.P. Miti, Lordship.
Dr. P.P. Learned Counsel for the petitioner and K. Boyso, Learned Additional PP for the state. Invoking 482 BNSS, the petitioner Nilamani Kolta is seeking anticipatory bail in connection with peaceful PS case number 802/2025. Full stop. Under section 108 BNS. FIR dated 1/10/2025 was lodged leading to this case, in which it was stated that the informant sister was staying in a rented house of one Mansi Basumutari was found hanging, and it is further alleged, it is further stated that his deceased sister had solemnized a court marriage with the petitioner, and date for traditional marriage ceremony was also fixed, but later he demanded money of rupees 5 lakhs and tried to delay the traditional marriage. Due to this, the victim suffered mentally and ultimately ended her life. Mr. Mehdi, Learned Counsel for the petitioner, submits that allegation about demand of money is completely denied. Semicolon, that there was opposition to their relationship from the family members of the girl, due to which she was facing pressure and the social marriage was getting delayed. It is submitted that the petitioner is not involved in any manner in the death of the girl, who happened to be the wife, the legally wedded wife of the petitioner. The case diary has been received. Full stop. The IO has also submitted a bail objection, stating that the accused had forced her to undergo abortions and also delayed the court marriage, thereby putting pressure on her instead. I perused the statements of two family members of the house owner where the incident took place. One of them has stated about that she was engaged to the petitioner and sometimes she used to visit in their house. Upon giving my anxious consideration to the matter, I deem it prudent to allow the petitioner to get his statement recorded while keeping the bail petition pending for a while. In such view of the matter, the case diary may be returned back and procured again for the next day. In the meantime, in the interim, in the event of arrest of the petitioner, allowed to go till 30,000 once year. Cooperative investigation may appear before the IO, making himself available for examination. And he shall not in any manner cause any harm or harassment to the informant side and their family. This will keep it pending.
Yes,
Say that you can give a longish date, no problem.
My lord.
30 January.
My lord, my
Get a
lord,
chance.
my lord.
I'm deeply obliged, Lordship.
No, it is, only part relief. Can I keep this judgment?
Yes, Lordship.
If you want, you can
Lordship.
take it back.
No, I have a copy. Lordship. I'm obliged, Lordship.
Maybe. But here in this case, my last occasion diary was called for. I am on interim. My statement has also been recorded.
30 lakhs.
39.
49, my lord, she did not receive, my lord.
There is an allegation of robbery of 30 lakhs. Jewelry.
Lordship.
Okay. Particulars. The petitioner was granted interim bail on 18/12/2025, and case diary called for, which however has not been received today. Full stop. Issue reminder, interim stands extended till the next date of listing. List on.
My lord, 21st, my lord, 21st, 22nd, any date, my lord, or any date.
His marriage was there, and he was summoned by notice. That is why the interim was given actually. Otherwise, the allegations are, he's not named, nobody is named.
My lord.
But
Well,
he
in
should-
those cases, my lord, used to my lord.
He
So,
can, in the meantime, you give
My-
instruction, he should record his statement.
Lordship, my statement has been recorded.
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 It is submitted by the council report, that after getting interim, he appeared before the IO, and his statement has been recorded. Okay. So list on.
my lord, 22nd, my lord,
22nd.
or 21st, my lord.
No, after next, thereafter.
After that, 28, my lord,
27.
27, 27,
27.
27. Okay,
27.
fine.
Lordship.
27.
Deeply.
In this case, Lordship, my name is not there, his name is there. If your Lordship permits, may I place the case on his behalf? Lordship?
Hmm.
My name is not there in the Wakalatnama, Lordship. I'm. The FIR, your Lordship will find page 15. Earlier, your Lordship has gone through this FIR while granting interim bail
Cricket
to
matter.
co-accused
That-
persons.
Cricket matter.
Yes, Lordship. Yeah. And just one thing I'm pointing out before going to the merit of the case, Lordship. During pendency of this case, Lordship, I have received notice under section 35 FC notice, Lordship, for appearance before the investigating officer. But as there was no interim order, I could not appear, Lordship. That your Lordship grants the same benefit which was granted to other co-accused persons, Lordship. He will appear before the investigating officer and disclose everything to the investigating officer, Lordship.
Yes. Yes. Can I go back to the original FIR?
Lordship, page 15, WAP 5.
You can use this also, yes. Similar other past. That's part two, you can take it. In this, there are two allegations too, you can take it from there. How is he connected?
It is alleged that, Lordship, he tried to contact with other players, Lordship. That is the allegation similar to other persons who were granted interim.
Oh,
bail,
I see.
Lordship.
It is submitted by Mr. Ahmed, Learned Counsel submits that he has received a notice under 35(3), and due to which and that though he's willing to appear, but he's apprehending arrest, and hence before this court. Full stop. It is submitted that similarly placed persons have been given the protection of anticipatory bail, and in support thereof, two orders have been passed. Full stop. Peruse the same.
My lord, CD receipt in this matter.
Oh, it's just.
Yes, my lord, CD receipt, my lord. We have received the CD, my lord. That is, my lord, already, my lord, there is 35 notices there. So, my lord, there is no, my lord, that is a SK until or everything is, my lord, complied with. Now, my lord, that's because CD is there, so my lord can dispose of the matter, my lord. If my lord go by the, my lord, that is the period of the, my lord, that is the offense, my lord, 60 days offense. Or if we look, it is a, my lord, case of match fixing, my lord, and we don't take, my lord, cricket is a kind of amusement game. And that is the industry, the worldwide, how it is becoming. And from our state also, the people are going and they are doing hard work to become a cricketer, my lord. Then it is a, my lord, very serious nature of case, my lord. If we say it is a, my lord, 60 days offense, and that's a case of match fixing, then not, my lord. The my lord may kindly peruse the, my lord, CD, my lord. This is a case, my lord, where, my lord, it is a, there is one, my lord, that is a trophy, that is 2025, my lord. There is a one trophy was, my lord, that is Syed Mustaq Ali trophy, my lord. That is a trophy, my lord. Now the accused petitioner, he is also a cricketer, my lord. He is also a cricketer. Now a chain of such cricketers, my lord, they whether we salute those cricketers, my lord, whether we say our young generation, even every one of us taken as an ideal for the country and the leaders, what they are doing, my lord, allegation is there. They tried to, my lord, match fixing. 2-3 people together, my lord. They, my lord, communicated their junior cricketers who are, my lord, participating at that, my lord, cricket tournament, my lord, and say that you, in this way, you make this sort of line, not before that. And because of that, you get a handsome amount of money, my lord. That is the allegation, my lord. It is a nexus, my lord. That is the Cricket Council, my lord. They-
Make a short ball or easy ball.
My lord, my lord, my lord. So, my lord, my lord, categorically, my lord, that is the investigating agency file, my lord, categorically, my lord, that is the objection prayer here, my lord. That is also, I have flag mark, my lord. Along with that, my lord, other, my lord, that is the link is, my lord, there, how all these people are connected. That part is there. And another one, my lord, that is the witness, my lord, who is, my lord, communicated this person. And that the amount is, my lord, that is, my lord, my lord, presented to that person. That is there, my lord. So at this juncture, my lord, to find out that this sites, my entire net, my lord, this is not a, my lord, our humble submission is there not a fit case of, my lord, pre-arrest bail application, my lord.
That one aspect, my learned friend has said, but the investigating officer has served me notice under section 35(3), which itself shows that he do not want my custodial interrogation, Lordship.
No, he has to give, he can still arrest the person.
Yes,
but
my
he has
lord.
to give
Still
reason.
has, but
Yes, my
what
lord.
my statements probably he required to be recorded. And after that, if he finds that there is other matters which required to be investigated, then he probably can.
Now, my lord, in this case, my lord, they, my lord, file a, my lord, objection. They said, my lord, his custodial interrogation is needed, my lord, because, my lord, other than that also, my lord, they find other, my lord, witnesses, which they say, my lord. So it is very serious offense, my lord. At this juncture, my lord, our humble prayer before your lordship is that no pre-arrest bail may be granted.
I'll record your submission. I'll.
My lord, may kindly peruse the CD, my lord.
Peruse it
Yes,
later.
my lord, my
I'll
lord,
take
my
the-
lord,
I'm
my
feeling
lord.
little
My
hungry,
lord, my
so,
lord.
so I'll see.
My lord.
But today night only you'll get the.
My lord, my lord.
Within night, but
My lord.
I'll record your submission, so
My-
because the learned additional PP, the case diary has been received. The learned additional PP, Mr. Boysa submits that the IO has also submitted a bail objection. And the prosecution supports the same. Investigation has revealed materials indicating materials lending support to the allegations about manipulation of games and corruption. Stop. The call detail records have also been collected over time.
My lord, there, my lord, they, my lord, some numbers are also there, my lord, even my lord,
Sometimes.
screenshots and everything, my lord. Before, my lord, lodging this FIR, my lord, their internal committee already make a, my lord, inquiry and call all those, my lord, that is the new cricketers, my lord. So things are there, my lord, but still it has to, my lord, go for a long, my lord.
The learned additional PP submits that considering the materials that has emerged, perhaps it may not be an appropriate case for grant of anticipatory bail. ... I'll look into it.
That inquiry report also a certified copy I have
See
obtained.
that also. See that. It's unfortunate if true, because this is also kind of, if it is true,
If it is true, then.
then it's a corruption. Not surprising also.
And
Corruption
in
is,
fact, their career is also.
corruption is destroying us, it is destroying us, really. Everywhere it is.
And
Because-
their career also will jeopardize because of these allegations. They are already suspended from ACA now.
Chamber.
Obliged also.
In this matter, my lord, we have received the CD, my lord. That was, my lord, on earlier occasion, my lord, that was called for, my lord. My lord, I need some, my lord, some time, my lord, because my lord, CDs, my lord, though received, my lord, because my lord, there are, my lord, various, my lord, but the lot number of accused numbers. Now, my lord, they are FIR name accused number 22, 7 and 6 before your lordship. Some more time, my lord, I need. My lord.
22?
My lord, here, my lord, that is the petitioner number 1 is a, my lord, accused number 22 of the, my lord, FIR, my lord. FIR name accused 22. My lord, petitioner number 2 is accused number 7 of the, my lord.
Different.
And my lord, accused number 3 is, my lord, That is, my lord, petitioner number 3 is the accused number 6 of the, my lord, FIR, my lord. But all are FIR name, only, my lord, I want some time to go some deeper, my lord. Because, my lord, many people's names are there. Maybe they may not be, my lord, implicated, my lord. Some more time, my lord, I need it.
Today only? Today only?
Today only I will go, my lord. I need some more.
Huh? No, that's good. Kindly, sorry. It 11 to 11 হবে স্যার নাম্বার সাপ্লিট দিয়ে আছে সবর সাপ্লিট কিবা দিয়ে আছে সাপ্লিট bill নাই rest of the matters I think it will be better if we take by urgency, you know, if there's anything urgent. Otherwise, hearing matters to.
Can it be, my lord, fixed tomorrow, my
No,
lord?
no, this I can take up.
Yes, ma'am.
After some time, half an hour is there, this I can take. Yes, admission is there, surely down. This was the part hard matter, no? Part hard matter.
Please, your lordship. By this lordship revision petition, we have challenged the order dated 19/6/2025. Your lordship will find that order is at page 30 and
Interim compensation.
yes, lordship.
Okay. Would you like to argue today or another day?
It is better for fix another date, lordship. Yesterday also I called my senior friend who promoted me because.
Please. Because I think not much remains to
I
be
mean,
argued also.
Yes, yes.
You have argued, I remember now. We have two options. One is so you just complete the remaining argument shortly and then I reserve it. In the vacation, I try to complete it. Or we keep it.
Because after make it fixed on after vacation.
What do you prefer?
As you decide yours. Lordship.
And then fix it on, right, 27. Paucity of time will you become? The matter may be, the interim order by 18/8/2025 shall continue. The matter may be kept as part hard should be bold for you, make it bold. Huh? And leave the matter on the
28.
Just a minute. On 29 at 2 p.m.
Yes.
On 29 at 2 p.m. We'll take it up. It will surely reach that till 2 p.m. because it's part hard. It can get priority.
Yes, right.
Oblige your lordship.
So here we have challenged the order dated 21/10/2022 passed by the additional CJM below, wherein the petitioner was directed to give a sum of ₹4 lakh.
Interim compensation.
I'm sorry.
Interim compensation. No. Wait. Just. Okay. Against conviction.
Yes, Lord.
Respondent's name is reflected in the cause list, but
Not there.
we are trying to settle the matter, my lord, between the parties.
Right. No, it's third round of, it's reached the third time.
Yes, third round.
Third time.
Appellate court has reduced my sentence. My lord, if your lordship reduce the sentence, that rest of the amount I will pay, my lord, include
I think-
quarterly.
because I think.
Only 2 month sentence is there, madam.
2 month sentence. Yeah, fine. It's I think it will be better to have it another day.
Yes, I have got no.
Another day. It will be
Yes.
better to apply the mind properly.
Yes,
But
madam.
okay, you just remind me or your junior.
Sure, sure.
If or that concerned court, whoever it comes in, that can also be one of your alternative prayer, that if it is reduced,
Yes.
it can be on those lines
Yes,
also.
yes.
In the meantime, best will be you settle.
I'm trying, madam.
Then it can get compounded and acquittal.
Yes, yes.
But you have to pay that in terms of that judgment.
Yes.
Damodar Prabhu, I think. High Court sessions 10%, trial court 10%, the sessions and High Court 15%, Supreme Court 20% to DLSA.
Yes, yes.
DLSA.
Yes.
That way I can release the matter after the beautification on a date to be fixed. Should I fix a date or?
Yes, yes.
Registry will it be fixed?
Yes, yes, yes.
Some dates we should leave
Yes,
for them
yes,
also.
yes, ma'am.
Because they can fix
Yes,
harmoniously.
yes.
After date to be fixed by the registry.
07.
Yeah.
I'm deeply obliged, madam.
Yes,
TCR not received in this case.
My lord, their case number is little peculiar, my lord. Therefore,
you are representing DRI?
Yes.
Okay.
my lord, that case number, my lord, may be mentioned. Therefore, perhaps confused, my lord. Vehicle is already given to Jimma to me by the Lane Trial Court, my lord. They are objecting and challenging that order, my lord.
Yes, sir.
And lordship, kindly look their case number in the order, page 45. This case number may be mentioned, my lord.
In other circumstances.
Otherwise, my lord, this is CGM matter would have come, my lord. Perhaps therefore they are confused, my lord. Page 45, my lord, this DRI, my lord, case number, page 45, my lord, down below, my lord, DRI case number 26, so and so, so and so, so and so, my lord.
This is not the case number.
This is the case number, my lord.
This is the case number, lordship, but the TCR which was called for was called for this particular case number.
Yes, my lord, it is above, my lord, page, miss case number 133 of 2025, my lord.
It was disposed by the learned editor.
Oh, that we don't need actually. Main case we need, isn't it?
Yes.
Main case and good, my lord, this miss case may be mentioned, my lord.
In other circumstances, lordship, TCR may not be required in this case. Because-
That I agree, my lord. TCR is not necessary.
Everything is annexed.
Yes.
Yes,
everything is-
and my lord, they are raising one legal issue, my lord. According to them, my lord, as per the provision of the act, my lord, they are.
Customs Act.
Yes, my lord. They are my lord, exclusive jurisdiction to deal with the my lord Jimma petition, my lord.
Lordship, this might take some time. Another date may be fixed.
Otherwise, my lord, my another Jimma petition along with this order passed by the Lana trial court is lying with them, my lord. Because directly I have not filed, my lord. Though I have submitted this order, my lord, formal application was also submitted to grant Jimma, my lord. But only for my lord, technical reason, my lord, they have come, my lord. And this is very costly, my lord, Leland Tata, my lord. Since long time, my lord, this is being damaged, my lord, in their custody.
Just a minute. The para 10, the learned magistrate has addressed this question.
Yes, Lord.
Rightly or wrongly, and you said that yes, that there is a provision for administrative adjudication also.
Yes, Lord.
By the customs
Yes,
authority.
by
But
customs.
that will not necessarily bar the court.
Lordship, in view of the provision contained under section 110A of the
A,
Customs
A,
Act,
yeah.
only the adjudicating authority has the.
That is the question, whether it is only the adjudicating
Yes,
authority.
in my view, it is only the
Okay,
adjudicating.
Can you look up some case law on the next
Yes,
day,
Lordship.
for the next day?
Yes, in the last occasion, I have submitted one case law of the Honorable Meghalaya High Court, Lordship. It is there with the case records. But in the next date, Lordship,
Yeah.
I'll bring more.
It's an interesting point.
Yes, Lordship.
We'll see. Otherwise, because then either parallel jurisdiction will lie, or because it is a criminal case, right?
Yes.
It has been registered as a criminal case.
Magistrate is empowered to take jurisdiction only when only when the offense report or the final complaint is filed under section 135 of the Customs Act, Lordship. That is when the magistrate takes jurisdiction, Lordship.
Okay, yes. Otherwise, it will proceed like this, that Only the customs authority will have the jurisdiction, and thereafter, if somebody is aggrieved, then he can come in a writ petition or criminal.
Yes,
petition from there.
repetition they can avail.
From
under
there,
226,
from there.
Lordship. That is different issue, but regarding the release and seizure, customs act.
In that case, there'll be not much to decide, or we have to decide that point, and then they can be relegated to that, to
Yes,
approaching
but,
that authority.
We
Uh,
also approach their.
Oh, it has to be set aside then they have to go to the authority again.
This,
For
this
releasing the
question
vehicle.
needs to be addressed here. That is
Heard Mr.
key book,
K. Brook and A.M. Borgia.
standing counsel DR.
The petitioner is, the petitioner slash customs department is seeking interference with order dated 24/6/25. Passed by learned additional session judge number 3 Kamrup, and whereby interim custody of a truck AS 26C9100 has been given to the respondent. Respond number 2. We submitted that there is a law point involved as under section 110A of the Customs Act. Only the pertinent Customs Department authority has the jurisdiction to adjudicate such prayer for interim custody. In the impugned order, the learned court below had held that despite the existence of such a remedy, the jurisdiction of the criminal court would not be ousted. Matter could not be taken up fully today due to paucity of time. List the matter on
21, my lord, kindly.
no, take it, don't say after that. Take some more time.
Yes, Lordship.
Some-
First week of February.
My lord, they
They are the losers actually.
Yes,
He's
sir,
gaining,
great
he's
man.
got the vehicle.
Vehicle is by like being damaged, my lord, unnecessary, my lord.
20, when? Suggest? You can
Yes.
suggest. Now we have to go to February also, gradually.
Yes. 22, my lord. Anyway, 22 January, my lord. Otherwise, my lord, short
February-
matter, my lord.
February first week.
29.
29, Lordship.
Diploma.
Lordship, there is one interim order.
Interim, what is the interim order? Interim order. Oh. Vehicle has not been handed over.
No,
Not yet, Lordship.
It's with them.
Exactly.
I see, it was stayed.
Yeah, it was.
Oh, I see. Interim order, right, order dated 3/9. 3/9.
3/9/2025.
Extended in the next date of this answer. That's why you want it slightly, but anyway, I fixed 29. Right?
Yes, Lordship.
Okay, no problem. You wanted earlier,
Earlier, my lord, kindly.
27.
27.
Huh?
One.
Diploma.
Adult admission, no? Adult admission. Oh, it is. I'm using.
Your Lordship, this matter notice was issued, Lordship. However, the service report is awaited, Lordship. Interviews.
Yes, ma'am, two.
Is the number-
Take one, huh?
So I think respondent number 2 has been appeared, Lordship.
You have appeared?
And for the respondent, I have filed Okalot number today only.
Okay.
So the first appearance sometime maybe.
No issues. Your good name, please?
M. Nirola, Lordship.
Nirola. N. Nirola.
M.
M. Nirola, learned counsel for the petitioner. And your
R.K. Sharma.
I.K. Sharma, learned counsel, enters appearance on behalf of the respondent number 2. P.P. Goswami, additional, learned additional, represents the state. Record has come?
Record is not come.
Not come.
Oh, we have not called also, I think. Next.
Last decision it was not.
No, we have not called.
Yes.
Entire case record you need? Entire case record? Washing, no? Yeah, very good.
Washing.
All for the case record of PRC number so and so, corresponding Tezpur PS case 467 of 25. Comprising case diary and charge sheet, that will do. Case diary and charge sheet, or and any other relevant document. So, list the matter on so and so.
So interim orders there. Lordship.
Interim order stands extended till the next date of listing. And you take a date, work out a date. You work out a date between yourself. Suggest me.
Second week of February, Lordship.
Yeah. 9/2. Monday.
Lordship in 71, Lordship.
Just a minute. It's yours? 21. Delay condemnation,
Delay
right?
condemnation is Lordship.
Preparing a criminal revision. Concurrence.
Here also service report is not received, Lordship. Lordship, I think, Lordship, I may allow to take fresh tape, Lordship. In the last occasion, Lordship has asked for the consignment report, Lordship. I think 3 months already expired. Did not trace the.
Okay, no problem. Here's the previous order dated 5/12/2025. The I has been filed for delay condemnation instead. Service upon private respondent is with learned Mr. Nirola, learned counsel, M. Nirola, undertakes to take it is submitted that they may be allowed to take fresh steps upon the private respondent. Respondent number 2, which is allowed. The interim order shall stand extended to the next date of listing. List in the orders column on, should you suggest?
February.
Same date,
Is
9/2.
9. Obliged.
Hearing matters কিন্তু করি জন করি automatic করি anybody for the hearing matters will adjourn it. Anyone's there? There'll be no time, right? No.
Item number 55, 56 and 57. Problem is, my lord, the daughter of the accused number 2, my lord. Item number 56 will be, marriage will be solemnized on 2/2, my lord.
Daughter of?
My lord, appellant number, item number 56, my lord.
Okay. Okay, will be, sorry.
Sister.
What is this matter?
Sister of the.
Against? এটা ফাইল করুন।
Section 6 of the POCSO.
One of our New Year resolve should be how to do more hearing matters.
My lord.
Somehow, yes. Because some matters has to be
prior to
listed for hearing, and they have to, we have to find a way out. We can make a slot that this time we'll take hearing in the course of the day. No problem. We'll reach. POCSO matter.
My lord. Take the matter on 27/1, my lord. 10 years. 10 years.
10 years. You are appearing for the,
I'm appearing for respondent number 2 informant.
so everyone is present in the prosecution. Myself at a loss actually, how to, I'm thinking of strategies, but still, we can fix suppose, for example, on a hearing day, we can fix a matter or 2. It will surely reach. But it will be, if you see it like that, without going into it, it will be unfair to the other matters who are waiting.
Yes,
We have
Lordship.
to have a
There are a number of
clear
matters which are still
policy.
pending.
We have to have a formula, because some matters have to be given precedence. But then on what criteria, right?
In this matter,
One
there's-
criteria can be he's in custody, suppose, that can be one criteria. But there has to be a criteria. Anyway.
1 year, 9 months.
Hmm?
1 year, 9 months in custody, my lord.
He's in custody.
Custody.
All are in custody?
Custody, all are. Three, my lord. Appellant.
arising out of the same judgment.
Arising out of the same judgment. 55, 56 and
57.
57.
Item number 56, my lord, sister of the, my lord, appellant, my lord.
Let us,
marriage will be solemnized on
I mean, we don't know how many matters above,
My
but we
lord.
don't know, but let's experiment, let's fix a date.
27/1.
In first week of February or something.
Lordship, he is suggesting some date prior to 2nd of February because 2nd February is the wedding. That is what he's saying.
Wedding of?
Wedding appeal number item number 56, Jivan Das.
His sister's wedding.
Sister.
Sister's wedding.
Sister.
After the wedding? Fix after the wedding?
But it is
Oh, so he's-
presence is required, my lord.
IA is pending.
Huh?
IA is also pending.
Lordship, again, this entire week of 12 to 16 will be vacation, so there might be some motion urgencies and all during that period.
When?
After the vacations.
Yes.
22nd or 27.
What do you say? Suggest a way out.
22nd.
Otherwise, we take up your IA.
My lord.
You have an IA. Another date we take up your IA.
My lord.
10 years conviction.
10 years.
You file objection.
Yes.
55, 56, it's a paucity of time. Paucity of time. Then you suggest a date.
As your Lordship pleases, Lord.
27-1, my lord.
Huh?
27-1, my lord.
No, the 27 is not a hearing day. Fix it on
It's a hearing day, Lordship. 27 is a hearing day.
It's a hearing day.
Yes,
At-
Lordship.
at
It's
2
a
PM,
Tuesday.
Okay. Fix on 27, 2025.
27-1, Lordship.
27/1, 2025.
26.
Huh?
2026. Yes.
Walking actually. 27/1, 2026 at
At-
2 PM.
At 2 PM.
Otherwise, it will not reach.
My lord.
Lordship.
The pattern. We'll take up and you come prepared and we'll.
My lord.
we'll-
Obliging.
Life.
I have a appeal minute item
Because,
54.
sir, another thing is that because the person objective with which you have given in the judgment, now I have to deliver the judgment also
Yes,
before that day. Yeah. Because whatever it is.
My lord.
Otherwise, we'll see. Otherwise, you, otherwise,
It is.
I know you, suppose it gets longer, suppose we cannot complete in one day, then we take up the IA
My lord.
also. If
Lordship-
necessary for the wedding, we can make some.
Lordship, ultimately, even if the IA is taken up, the entire merits of the matter need to be gone also. So it will amount to a double exercise if the IA is taken up without the
Better
appeal.
we take up the hearing only.
Yes, Lord.
No, for the wedding, we can maybe for some interim.
Lordship,
arrangement.
there is no application to
10%.
that effect as on date. There is no application with regard to the wedding. The IA was filed prior in
Yeah.
point of time.
True. No. In the IA can be, some interim order can be passed in the IA without disposing it off.
Lordship.
That's one option, I'm saying.
One option.
I cannot pronounce my mind,
Yes.
of course, but that's one option.
Some protection will be until.
For the
period of time.
wedding.
Certain period.
If you oblige.
Obliging.
Please, your lordship. Item 54, my lord. Here I also pending, my lord. Here 8 years conviction, 304B, my lord. And here, my lord, about 2 years, my lord, he is in jail, my lord, because initially he was 3 months and now it is 1 year, 8 months, my lord.
Take a day.
So I is pending. So if possible, my lord,
After
I may be
vacation.
taken up.
No, today there will be no time. I have to take up on bail matter also, spending, that's the last matter. So after the vacation,
Otherwise, my lord, a case of acquittal, my lord, as per my
we'll go into it.
view.
We'll go into it, definitely. List the matter after the due holidays. On a date to be fixed by the registrar. Let's keep it like that. If it does not get listed, you make a mention.
But,
You make a mention.
my lord, date may be fixed, my lord. Otherwise.
No, doesn't matter.
pick
That
up.
day I discussed also. Nowadays things have changed. They use technology also. It will not get lost. Earlier times are different. And if it does not get listed, mention is always there. Don't worry.
So many occasions.
Don't worry. You make a mention. You make a mention.
In hearing matter, actually, when mention is not accepted, it's a problem.
No problem. I don't know. Maybe in a different.
Because I is pending, this is a problem, because in every time, my lord, the matter comes in hearing,
Insisting so much.
and matter of 2024, I
As
think
I said,
I may be
you
listed.
have to find a strategy regarding hearings also. Three zero will do. 30. 30. But it's a motion day, 30.
Yes, sir.
30.
30.
30.
And plus.
May I please, Your Lordship? My lord, before my learned colleague, my lord, started, my lord, I had gone through the, my lord, this case diary, my lord. 3 years bail application for 3 accused petitioner, my lord. Already they are FIR name, my lord. But my lord, there is the PM report because the, my lord, date of occurred, 2, my lord. 2 numbers of persons died, my lord. That is not available with us, my lord. So because of that, my lord, updated CD is needed, my lord. Along with the PM report, my lord.
Yesterday, Your Lordship, some bail applications were listed. And those are most, I think on 21, it has been fixed, Your Lordship.
Connected bail?
Yes.
Connected bail?
Yes.
Same affair, no? So then, my lord, 21, my lord, then it will be fixed for 21, my lord.
Is there
We'll
a
send back
receipt?
the CD, my lord.
But case diary is received, but what is not available?
My lord, postmortem report.
The PM report is not available. And additional PP submits that it may be necessary to peruse the PM report. The Fund Learned Council Commissioner submits that connected matters are fixed on 21st. This is the matter on call for the case diary will be returned back. Return back the case diary and to be procured again. But for the
hearing,
next day, list on 21/1, 2026.
Next day.
This week, actually, this roster, I was planning that 4 to 4:30 every day, I will hear order matters. I was planning.
Yes, man.
But I could not give the instruction.
My
It
lord.
got late, so now it's already over. Week is over.
Man,
No
after,
point.
after my lord,
Suppose
this
I
vacation, my
play
lord.
another time
Yes,
in
my
the
lord.
roster.
My lord.
That
Then
can
that
be-
will be
this is
beneficial,
the-
my lord.
no, because that is the only way we have to solve this problem.
My lord.
You have to make slots.
My
Because some
lord.
matters cannot wait, like
Yes,
bail.
yes, my
After
lord.
you do bail, then you do a little bit of admission, and then you do a little
Yes,
bit of
my lord.
orders.
My lord.
Then it can always
Yes,
reach.
my lord.
Always it will reach.
Yes, my lord. My lord. Deeply.